Redefining diversity, competence, integrity, and work ethic through one location, one phone call. Introducing Signature Hill.
We welcome you to this CAPE Institute class in August, and my name is Attorney Angelo Pepa, and I've been teaching for CAPE Institute for quite a while. I know the owners of the company, and they're just nice people. And we try to present CLE classes a little differently. We want to give you plenty of substance. And that's why we have a lot of printed literature on your desks there. My job is not to stand up here, I don't think, and read to you. I think I like to try to make it a little more interesting than that. So in that vein, we will share personal stories and things like that, and maybe keep it as alive as possible. But you know how to read, we know that. So you can take home any of that material, and you're encouraged to do it. A couple things that I want to get out of the way right away is that concept. One of our most important research pieces is the document called Drug Court Research. Okay? That's a book of some of the most comprehensive and most recent, although maybe not the most recent, research on this topic. Now, I do want to say, before we even go any further, that many times, and maybe even most times, I disagree with some of the conclusions of the research in here. I am not saying that I or CAPE Institute or anybody else is buying into the suggestions that follow the research, but the most important value of the research is the idea that we are starting a debate. Many times, people don't even know what they don't know. That to me is the highest level, lowest probably, a better way to say it, of incompetence that there is. Question, how many people in here know that since October 2011, there has been an FDA-approved drug on the market that is non-addicting, that will prevent the reward system in the human brain from responding to drugs or alcohol, i.e., prevents the reward for an alcoholic or an addict and puts cravings in remission? How many people honestly know that or knew that when they walked in here? There are no hands for the camera, by the way, I'm saying that. And I'm amazed at how many times I see that. That's a pretty startling thing when you think about it. And more startling is the fact that no one knows it. In our business, no one knows it. And that's probably even more frightening yet when you think that traditionally we arrest 1.6 million people every year for substance abuse-related crimes. That is a 40-year pattern of our war on drugs. So when I'm talking to a group of lawyers and no hands out of a group of 30 to 50 people come up when I ask them about that, that tells me that we need to begin and maintain a debate, okay? And I'm not telling you shouldn't say, well, gee, what's this medication for or whatever. Certainly you should have your questions, and you should. But now you should be looking into and investigating that, because there's a lot of people out there who need help. More statistics for you. And they're all found here, by the way, in this research piece. More statistics, basically. Another issue is that overdose is the second leading cause of death in the United States today, second only to vehicle accidents. How many people knew that? Okay? That's an amazing thing. We also know that only 1 in 7 people will admit that they have a substance abuse, alcohol, or drug problem. And tragically, only 1 in 4 will seek any type of what I have come to call random treatment. So The neat statistic, though, the good news is that 37% of those people who do are referred by criminal justice. How many people in here have ever done or do criminal law? Okay. Kangaroos have a little wee arm. Human beings have two segments, so I need you to do it a little bit higher if I call on you to answer a question, okay? You've got to have fun doing this, too. So if we know that 37% of those people who do seek treatment are coming from criminal justice, doesn't that start to ring clearly that there is an opportunity here to do something about this very important problem, and it's laying right on the desk of the attorney? This whole program, our whole class, is entitled Being a Good Lawyer. It's not being a perfect lawyer, by the way. I don't think there is a perfect lawyer. I don't think there's a perfect anything. But it's not being a perfect lawyer, but it's being a good lawyer. You know, you hear it all the time. Good boy, good girl, good doggy, good anything. It's good isn't that our gold standard? We don't have to be perfect, but I think we should be good. So if we're going to be good, what does good mean? Now, I'm really excited because Alexander Lindsay, who teaches trial tactics at Pitt University, and I see some people nodding their heads, you know he's a great storyteller, and he's a great communicator, and he's a great lawyer, and he's a good person. He's a good lawyer. So Al is going to close our program off today at the end of the day for the last 2 hours with an hour of historical issues on what lawyers, and I'm telling you, when you leave here, if you sit through that first hour, you'll be proud you're a lawyer. And you should be proud you're a lawyer when you walk in, but maybe sometimes we need to remind ourselves again and to recharge our battery. But being a good lawyer is important. Again, not a perfect lawyer, but a good lawyer. So what's a good lawyer do with those statistics and facts that we just talked about? A good lawyer is aware of them, first of all, that going back to that competency. Now, this is probably Mr. Ludovisi and I have been hanging out on this project, Dante, 13 years now this past month. We've been doing this for 13 years. We've been talking into that camera, off of that camera, in front of student bodies, in front of lawyers. For 13 years we've been working on this project. And so I have come to see where I traveled from. I was a person who didn't know what I didn't know. I remember the first time I had a substance abuse case that became one of these patterns in my office. Just a general overview, I had a young man who was accused of a substance crime, possession with intent to deliver, and possession, simple possession. Family came to me. I went to the preliminary hearing. It was really neat. It was done. It was over. And by the time his case, before we got to the part in time where we actually pled him and entered him on his probationary deal, he was arrested 3 more times. Now, we charge for everything we do at our office, and that's not what we call good business, is it? Because don't you feel bad when these people have to keep paying another retainer on another file? But you're in business. You can't afford to work for free. The person who's not paying you is keeping you from working for somebody who would. Okay? So what's happened there is it caused all at once a dilemma and a little bit of a stomachache. And I started thinking to myself, man, I had the parents in and I said, every once in a while there's a person out there that just is a criminal. And maybe you should get a public defender or something like that. I've never seen something like this. I'm talking within weeks, he was arrested 3 times. So by accident, an attorney was talking or walking past my conference room and said, hey, did you ever hear that? There's a doctor on Wilkins Avenue in Pittsburgh that they have some kind of medication now that's like really kind of neat. And okay, so I put the best navy blue suit on I owned. That's how I am. And I went right to his office. I sat there, and I think he thought I was a patient. Eventually, he's looking back and forth, taking care of the people who are in his waiting room. And I said, excuse me, I don't have an appointment, but I'll gladly pay you what somebody would pay you. I need to know what's going on. And way back then now, we're going back 13 years. Back then, there was a substance called naltrexone. And naltrexone was in tablet form back then. It was called Revia. And Revia is a pill that you take, and for 24 hours, generally speaking, and by the way, I am not a doctor. When I talk about these kinds of issues, I am parroting what doctors I work with have told me. I want to make sure that you know that. Anything in the medical area, you need to do your due diligence and check on. I'm merely telling you generally what my experience has been and what doctors have told me. But anyway, the doctor basically went in to tell me that this naltrexone somehow blocks the receptors in the brain. In our brain, we have various receptors that respond or not to various things, and the euphoria, the dopamines that are released, those things happen, and you can block some and not all of the receptors. It's still amazing to me that you can do that. But this pill will basically keep an addict or an opiate addict or alcoholic from the reward system from being triggered. Now, the pill back then was something that fluctuated depending on metabolic rates and things like that, medical terms, and based, like every 24 hours, sometimes it would be 20 for somebody, 18 hours for somebody else. And then, of course, if you forgot to take your pill, there was a problem. And now we've jumped clear to the point in time where it's injectable, and it'll last for 30 days. And it's a deep muscle injection that'll last for 30 days, and it'll prevent the body from responding to opiates and alcohol. And the FDA approval says that it prevents the relapse of drug and alcohol. Anyway, so generally speaking, that medication was out there, and I needed to know more. So again, what does a good lawyer do? Well, the first thing a good lawyer does is find out what's going on, find out something you don't know. All right. Now, and that's basically what this research is about. It is the latest research. Now, this research, and I want to talk a little bit about that because it's important that you know it, there are hundreds of bibliography sources in the back here that are very, very, very important for you to know they're there for you. Those bibliography resources allow you to walk into court empowered, right? Knowledge is power. And it might be important for you to know that sometimes you're talking to the judge and he doesn't know things you know. They can't know everything. The law court can't know everything. Don't assume when they're looking at you quizzically that they're disagreeing with you or saying, wow, you're off at first. No, we have an obligation as members of the bar to push this thing a little bit when you know something. There's an old saying that says, you owe what you know. Don't we? Or we're lawyers, for crying out loud. My wife will tell you I keep an inflatable podium in the trunk of my car. If somebody wants to hear a speech, I'll blow that thing up and be talking to you in minutes. But that's who I am. When I know something, I want to share it. And I'm encouraging you to recognize who and what you are and share information that is vitally necessary. Now, going back to our research material, basically there's 3 basic articles. Back in 2009, the National Association of Criminal Defense Lawyers came out with a study on drug courts. First of all, what are drug courts? Well, the war on drugs basically started, for the most part, in the Nixon, then transitionalized into the Reagan years. Does anybody here as old as I am and you remember Nancy Reagan say, just say no? By the way, that's important. We'll get to that issue later. But just say no, wasn't that a little simplistic? Back then, we thought it wasn't. Just say no. What's wrong with you? Don't do drugs. And if you do them, we're going to put you in jail and throw the key away. That was our paradigm back then. That's 40 years ago. We've lost $1 trillion on that war on drugs. In every other war we've ever been involved in, we would never tolerate that kind of success rate and that kind of expenditure. So that's the war on drugs. 20 years into the war on drugs, 20 years ago, approximately, we started doing what's called diversionary courts. Diversionary courts, a quick example. Anybody know a quick example of a diversionary court? By the way, so I don't have to walk off camera, I'm going to ask my good friend and colleague, Bruce, if you could grab me something to drink, because my throat's getting a little bit... But anyway, let's go back while Bruce is doing that. Diversionary court, right? Everybody hear of an ARD? You know what an ARD is? What's an ARD? Anybody? Accelerated rehabilitation disposition, right? You were drunk driving, and we're going to let you skate one time, basically. But you got to take classes, and you have to not clog up our system and not require us to have a trial. So that's kind of what we're doing. Now, the national, thank you so much. No, it's not vodka on camera, by the way. It's plain water. By the way, I'm one of the lucky ones. I get sick if I drink. I get sick if I drink. I really get sick if I drink. And I don't even like the taste of it. Again, I'm lucky. So going back to diversionary courts, ARD. So what happens is the court system has so many of these that they will, take this, am I okay? Okay. They will take this stream of humanity that is coming from the public into the doorway of the courthouse. And I keep changing colors to get one that really isn't dry, by the way. They keep coming into the courthouse, and all of this due process, preliminary hearing, preliminary arraignment, waiver or arraignment, bill of particulars, discovery request, pretrial omnibus motion, call to trial. I have a real pet peeve on call to trial, by the way. We'll get to that. Anyway, call to trial, pleading, going to trial is a lot of stuff, right? So what happens is on ARD, they are diverted away from all of that into a processing system. It's a diversion of all that flow. Now, the diversionary court system is a drug court. These drug courts were created, there's about 2,200 of them. Now, that's important for you to know if you do criminal law. And by the way, I'm encouraging everybody in here who's a lawyer, even if you don't, I think you should do criminal law. I think when we have problems that big and you want to be a member of a community, you should help and roll up your sleeves. Plus, it's good business, quite frankly, because those people need you too. Again, let's go back to our statistics. We know we arrest 1.6 million people a year. Do you know that although we only have 5% of the world's population, we have 25% of the world's prison population? That's staggering. That's not good. That's not a good thing. Now, I ran for district attorney once upon a time because I was a member of my community, and I'm kind of like wanting to roll up my sleeves and help a little bit. The power of the pen. Prosecutorial discretion, it's called. Okay. We know, and if you don't know, I'm going to teach you that probably a district attorney is much more powerful than a judge. A district attorney approves charges with the power of a pen. When those are approved, we go to a what? Help me, people. We get preliminarily what? Arraigned, right? So those of you who are not criminal lawyers, I'm going to tell you what an arraignment is. Sometime this evening, it's a Saturday evening, I'll probably be somewhere with my wife, and my words will stop coming back to me. And I won't know why. But then I will get it that somehow I ticked her off. I won't know why. I won't know how. I won't even have pretrial motions or sentencing or guidelines, nothing. I'll go straight to convicted and punished and everything else. That's called not being arraigned, okay? Everybody who's charged with anything in this country has a right to be arraigned, okay? Now, when we have the arraignment process, it's preliminarily at the magistrate, the first thing that happens is we have a preliminary hearing, and it is not a trial. It's not a guilt or innocence baby trial. It is a, help me criminal lawyers, what kind of hearing? Our sufficiency, right? Sufficiency of the evidence. Actually, a magistrate legally is almost required to believe all the Commonwealth's witnesses, right? Okay? That's kind of runs parallel to the grand jury system in which a defendant doesn't even know they're talking about him, and they're certainly not allowed to be there. So don't be offended by that. Oh, that's not fair. That's all about sufficiency. So if we know after the DA signed a piece of paper, if we know the magistrate is only looking for sufficient probable cause, and we know that that's going to be bound over as a matter of law, we know it's very easy to be charged with a crime. So that prosecutorial discretion is very powerful. Now we have a case that's bound over. Now we have maybe mandatory sentencings and whatnot, and it's rare that a judge will ever dismiss a case. So a person almost has to plead rather than go to trial. Okay? You see what's happening here? That prosecutorial discretion from that pen is probably more powerful than even a judge if we're dealing with somebody who's innocent or somebody who has a health problem instead of a legal problem. And that's where we're going with this substance abuse. Anyway, going back to this research here. This research in 2009 began with National Association of Criminal Defense Lawyers. And the National Association of Criminal Defense Lawyers, and by the way, there's a gang of things that they don't like about drug courts and a lot of things they do like. It's all in here. It's a nice debate back and forth. But one of the most important things was that we were sacrificing the Sixth Amendment rights of a defendant by just putting him into the diversion. You know, how many times have you been tempted when you got somebody come in and say, okay, how many DUIs have you had in the last 10 years? None. Immediately you think of what? ARD. But you also should think a little bit about whether or not the stop was good, okay? Whether or not you can suppress the evidence, whether or not this is fair. So the diversionary, they have a chief gripe here, the Association of Criminal Defense Lawyers, that too often we are sacrificing Sixth Amendment rights that should be tested and diverting people. So now, not only ARD, but now we know we have diversionary drug courts. So they have some really neat arguments in here, National Association of Criminal Defense Lawyers. So that study came out around 2009, and then March 2011, 2 years later, Drug Policy Institute and Justice Policy Alliance came out with their own articles, picking up where National Association of Defense Lawyers left off, making this argument that incarcerating, and by the way, the big issues, the small issues you can read about, they're kind of neat, but the big issues was that, and all of them tended to agree, that we should not be incarcerating people with substance abuse problems who are not criminals, okay? And criminals, again, going back to that prosecutorial discretion, when I was indicated to you about running for district attorney, I live in a community and I thought I would have the maturity to use that pen sparingly. And I was running because I did not believe the people who were running had that overall wisdom or life's experiences. When I was their age, the guys who were running against me, I probably didn't either. So anyway, it's a very important position, the government attorney, district attorney. So, going back to our research, Drug Policy Alliance, Justice Policy Institutes talk a whole lot about legalization. Now, I'm not opening up that can of worms because I got ground to cover, and we're going to keep going here, but how many people here, show of hands, think that we should just legalize drugs? Not all of them, but at least most of them or something. How many legalized people we have in here? Okay, now it's my theory, which means it's worthless. Okay. It's my theory only. Not coming from any research, but in my years that I've been alive, okay, and in my years that I've been alive, I've been around the block a few times. I was an undergraduate in a small school. I played college football. I've been in athletics a lot. I coached football and taught school. I was an assistant principal in a high school. I went to law school at night at Duquesne. Drove from Newcastle every night to class. I still don't know how I got in, much less got out of law school and survived that, working full-time as an assistant principal. But I think, you know, it's my opinion that God remains anonymous by coincidences, and I'm one of them. Anyway, in all of that said, throughout most of my life, and even as an attorney, I was a prosecutor for 7 years, an assistant prosecutor. I have now always been an accountability guy. I think that a defendant, probably, even if innocent, certainly made some mistakes to get in trouble. So I like to correct the mistakes that are being made. So I think the legalizing people are basically adopting that attitude because they don't know how close we are to maybe making some progress. Remember, nobody knew about this non-addicting medication that can help a person. And it's very important for us not to overreact. Isn't that kind of one of the fallacies of a democracy, which is the finest form of government, and I will always die defending that, but aren't one of the weaknesses, one of them, the idea that we just react like water, flowing up, and then it hits a wall and flows back, usually too high, and keeps on going until it finds itself level. I think that the legalizing thing has momentum that it shouldn't have, and it's an overreaction rather than, I think people who argue legalizing are basically people who don't know that there's some other options out there. Wow. I stopped on purpose for you on that one, sir. I think that the legalizing argument has some real soldiers committed to it, but I think for the most part, it's because they don't know there's other options. And I hate to surrender if we're this close and just say, let's legalize everything. We've just seen that recently, haven't we? How many people here saw on the news that the Attorney General addressed the American Bar Association earlier this week? What did he say? They're not going to arrest anybody anymore. Isn't that amazing? Were you as startled as I was? Not. He didn't say they're not going to arrest anybody. I want to make sure it's fair to the guy. But he basically said, when it comes to nonviolent drug offenses and whatnot, he's told his agents not to arrest them. Okay, I'm startled by that, by the way. I'm just amazed. I mean, aren't we supposed to correct the law if it's a bad law, not just refuse to enforce it? That's getting kind of crazy to me. That's my opinion, but that's only my opinion, and I'm saying it. But the bottom line is, this problem of warehousing all these people at $70 a day, each one of them, it is reported unofficially that it cost every state in the union $20 million every 24 hours for these low-level drug offenders that are in jail. So that brings me to another point, though. The Attorney General is probably doing that because he recognizes that legislative law is different than common law. Legislative law is law by committee, is it not? And let's take a look at the drug courts, for example. It's probably an illustrating point. On one hand, you have the let's hang him high, put him in jail for life imprisonment in Texas once upon a time or wherever for having marijuana. And on the other hand, we have people saying that the only thing wrong with this person is that something went wrong in their life in childhood or something, and really there are no such thing as criminals. And who are we to judge and stuff? So when you got two different competing interests like that sit in a legislature, it's very productive in a democracy, government by representation, but it does create some confusing statutes. And it's respectfully submitted to you that most drug courts are products of confusing compromise, talking out both sides of its mouth because it has two mouths. It has some people that are conservative, tough on crime, and some people that are very liberal. This research, by and large, all three major components of this research make compelling arguments that drug courts are very good. Diverting people is very good. Some people don't have the guilty mens rea, right? The guilty mind. They have a health problem instead. Got it. Okay. No legalizing there, but also an analysis as to whether or not they're guilty or not. However, what's happened, though, is that the competing interests are saying, but we're not going to let just anybody be in drug court. You have to have nonviolent. And I'm going to step off camera a second to retrieve a document. And I have a county here that has a drug court program. And generally speaking, drug courts are creatures of the local president judge. He's usually the presiding person. Although I found an interesting thing happened to me the last couple of months in that area. But drug courts basically outline a list of disqualifications. First of all, you have the issue is, do I need to plead guilty to get into drug court? Now, we got that Sixth Amendment problem, don't we? At least in an ARD with DUI, you don't plead guilty, and if you wash out of ARD, you still go back on the trial list, so you're not prejudiced that way. But most drug courts, bless you, require you to plead guilty. National Association of Criminal Defense Lawyers, justifiably all over that issue. Generally, if you have a history of violence and problems with drugs, you can be disqualified. So rather than go into all those details, if we have a drug court diversion, but we only let first-time offenders, I'm creating an artificial hypothetical to make my point. I'm not saying that's what drug courts do. But we only allow first-time offenders and nothing else on their record. The result is, and this research shows it with compelling evidence, that we are putting people who don't need drug court into drug court, and we're eliminating people who need to be diverted not into drug court. So what's happened is they've created two systems, the old way for most, and the new way for people who aren't really a problem, and they have doubled the cost of everything. So isn't that just like what we do? Anyway, and that's some of the research that's in this argument. Now, the one thing that they all seem to agree on, and I certainly agree with it, is that a judge is not probably in a very good position to make the decisions for drug court. What they're looking for is a local, health-centered approach to assigning drug court remedies. And drug court remedies are being most often made by judges right now. Okay, now how does that work? Okay, remember I told you I just had a problem come up about a month ago. I had two people that I wanted to put in drug court. They were perfect for drug court. We're rejecting that. You're not allowed to put them in drug court. Does anybody here have a problem with the DA being able to say who gets ARD and doesn't? Do you know that, by the way? Criminal lawyers help me. Or do we know that each DA controls his county on who drug? Now, anybody here work in Butler County? Okay, in Butler County, they have several criterion that we know that serious body injury or something like that could disqualify you from ARD diversion, okay? But a DA can add extra things if they want, just quirks that they want to add. Pardon me?
As long as they have a policy that's consistent, they're not making arbitrary decisions.
Thank you. She just said, and by the way, the microphone probably didn't pick that up, as long as they're not making arbitrary decisions, okay? Now, we also know that a DA does not have to give a plea, offer a plea at all, right? Okay, and I have that thrown in my face all the time in drug court, ARD, and plea. But this lady in our first row here, second row really, touched on something. And something that, again, we fail to lose sight of, that we're lawyers. When somebody, it's like the Olympic swimmer, okay? The Olympic swimmer walks past a baby drowning in a mud puddle, God forbid. Remember that case from law school, or that discussion? And he has no duty to save that baby, right? Horrified all of us in law school. But if he puts one toe in that water, he now has a duty to do it properly and could be sued, right? Got that? Okay. It's my opinion that I'll go with it that the DA probably isn't required to offer plea bargains. I'll go with it that the DA isn't required to offer ARD or whatever. But I think that once you do, right, you have a duty to do it without being arbitrary, without being capricious. Okay? So Is that an argument that's really a great argument in court? No. Is that an argument that's going to annoy the judge? Yes. Okay. Is that an argument that everybody's going to say, what the heck's the matter with you? This is what way we do things around here. So, but I think it's very important for us to go back to that good lawyer. Does a good lawyer prepare for that argument and make that argument? Now, a good lawyer can't do that unless a good lawyer knows what he or she is talking about. So again, it goes back to this research here and all those hundreds of bibliographies. Okay? So, in the drug court issue that came up a couple weeks ago, in 2 counties, by the way, one of them a couple hours from here, another one very local, is that you're not being offered ARD. Fine. Why? So no response to the letter. Well, I think I have a right to know why. Because if other people are getting it, I have a right to know why. And nobody will answer that because they know then they have to defend that. That's actually a subject of a pending motion. And the other one was, Your Honor, I have offered my client for a drug court, and the adult probation indicates to me that you no longer want him to be in the drug court. Yes, Mr. Papa, the committee met a couple days ago, and they've decided that he's not a candidate for drug court. What committee? When did a committee meet? Where's the star chamber that they had, you know? What are you talking about? A committee met. Your Honor, I'm here to talk to you. I asked for a hearing on the subject. I'm here to present my evidence why I can show that this guy is a very good candidate for drug court along with the criterion you have. Maybe not perfect, right? Like zoning law. Anybody here do zoning law? Ever been in front of a zoning board? Asked for a variance before? Maybe a private person. You got a fence put in your yard. There are laws that say no fence in the front yard, except if you get permission. Are we having a battery issue that I need to, okay. Except if you get permission. I mean, at least the zoning law allows for a variance when you can show people that the criterion that normally supports the prohibition, in this case, is not applicable. And that's what good lawyering is, okay? And you can't tell me, you can because you have the robe on, and I lost that issue, by the way. I'm probably going to appeal it. But you can't tell me, and me go quietly into the night, that I don't have a right to have a hearing to show that your system does not worthily apply to this set of circumstances. Now, let's talk about what a good lawyer talks about. And this is a very important moment. Anybody ever in here have somebody send them a letter saying that, better withdraw that, that's frivolous? Right? Frivolous is the word that we're all afraid of, because if it's frivolous, number one, we look like we're ambulance chasers or something. It's a blow to our ego. But it also could expose you to sanctions. And to be sure, nobody should file frivolous litigation. And frivolous is one of those issues that can be found in our ethical rules. And if you want to look up the rule on competence in your ethical rules, you will find that a competent lawyer is a lawyer who would not file something frivolous, and it's under meritorious action. I believe it's Rule 3.1 or thereabouts. I'm trying to find it right here, and if I can't find it right away, I'm going to just move on. Yeah, 3.1 meritorious rules. A good lawyer should know this, to not be frivolous, but to also not be pushed around either. Okay? To not be frivolous, but not be pushed around because that client hired you, and you're all he or she has on that day and time in that courtroom, whether somebody's mad at you or impatient or wants to get out of there, or you're going on and on and on. Let's talk about 3.1 in some of the comments. A lawyer shall not bring or defend. Notice that's bring or defend. That's plaintiff defendant. Bring or defend a proceeding or assert. Get this, not just bring, but assert. Or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension modification, or reversal of existing law. Don't you love how they write these things and they keep bouncing back and forth and back and the verbs keep changing? They're sounding very scolding in its tenor that you shall not bring, defend, assert, not just a claim, an issue, it says. We learned from collateral estoppel versus res judicata a long time in law school the difference between a claim and an issue, okay? That is frivolous. But then it also says, which shall include a good faith argument for an extension, modification, or reversal of existing law. Now, if you go down into the comments on that section, and I'm going to go to comment 2, the filing of an action or a defense or similar action taken for the client is not frivolous, merely because the facts have not first been fully substantiated. How about that one? You know, when you make pleadings, right, remember, believes and therefore avers, okay? I believe I'm going to be able to prove this. Or because a lawyer expects to develop vital evidence only by discovery. What is required, here we go, they're going to switch again on you. What is required of lawyers, however, is that they inform themselves about the facts of their clients' cases and the applicable law and determine that they can make a good faith argument in support of their clients' positions. Such action is not frivolous, even though the lawyer believes that the client's position ultimately will not prevail. How about that one? It's not frivolous, even if you believe you're going to lose. Okay, the action, switch again, they're going back and forth. The action is frivolous, however, if the lawyer is unable to either make a good faith argument on the merits of the action taken or to support the action taken by a good faith argument for an extension, modification, or reversal of existing law. So, it sounds to me that the law clearly contemplates you saying, Your Honor, I understand what the rules are in drug court, but they're not fair this time. And I think I have a right to a hearing on that issue. I understand why you have rules on ARD, but the way you're applying it to this case is arbitrary, capricious, and not supported by the reason you even have the program. Now, you can't make that argument, can you, if you don't have courage, if you're afraid that someone's going to yell at you in court. Maybe that's one of the reasons why I think I do a good job in court, because I've been yelled at my whole life. Coaches, principals, parents. You got to get over that. I mean, you're an advocate now, and you got to get over those ego things and just do your job for your client. And because, again, you're all they have. I had a class once upon a time, and I have to tell you this, I tell this story all the time. I like to insert personal things too, because I think as lawyers, a good lawyer is able to empathize with people. A good lawyer is able to be compassionate. Check out, you wordsmiths, a lot of you guys get into words, and they are kind of neat. I listened to some of our priest definitions, and it's kind of neat. But the word compassion also includes companion, doesn't it? There's all kind of word derivatives there from companion. Someone to talk to. Someone who, I feel your pain. The politicians say it, it's made it sound cheap and phony and whatnot, but somebody who feels your pain. Right now, I'm going through a thing here. Today is a Saturday. I have a little daughter. She's 18 years old, Bruce knows. I have 3 kids. One's an attorney, been with me for 4 years, and I have another daughter who works in Arizona. And my 18-year-old is a tomboy, okay? And she's always worried about kids picking on her in school and whatnot. Although once upon a time, a basketball coach, she was playing on boys' teams, one of the other kids complained, and he's shoving under the hoop. And apparently, I heard this later, he said, punch her in the mouth. And the kid looked at him like this, and then the coach said, and run like hell. Because she could probably take care of herself. But Annie has literally never been out of my sight since she's been alive. I mean, when I get cancellations and appointments and whatnot, I'm heading home and we're playing catch in the yard. She's a great fast pitch softball player. She has an arm like a bullet. She's a catcher. She's a wall. She stops everything. She hits, the other day we were in a tournament, they actually quit giving her the MVP tournament of the game, because each of the games, because it was getting weird. Nobody else could get one. So she had 3 of them, and the last 2 they gave to other kids because she just had too many of them. Anyway, she's got accepted to school in Daytona Beach, Florida. Never been out of my sight. I got to take her Tuesday to Daytona Beach in Florida. So here I am on a Saturday doing this, right? And I'm struggling with that. But my point is that when you can empathize and feel someone else's feelings, and I know I see faces out there. I know some of you have had kids that are going away or will be going away to school, or other things that you just got really attached to and you just want to let go and whatnot. Those are the kind of connecting moments on that. And so going back to the drug court thing there, that argument is something that you have to understand and know your client, of course. Now, you notice when I read those comments in there on what is frivolous, that the lawyer has to know his facts. You can't have your Benny Hill conference. Does anybody know what a Benny Hill conference is? Anybody know who Benny Hill is? Yeah, great. It's the old guys, right? Benny Hill is like a legend, basically. But there was a skit, I don't know if you remember it, but Benny Hill, I don't know if he was an accountant, a lawyer, a psychiatrist, I don't know what he was, but all I remember is this skit in which he was sitting stoically at a conference table, and he had his chin here, and he was listening intently, and this lady was sobbing, and she's telling this story, and every once in a while she'd get a smile on her face, and you could tell she was starting to feel better, and he's sitting there, and he's sitting, finally, you're not hearing anyone talk, it's all like silent. And she, thank you, and she walks out the door, and a couple minutes later, he goes like this. Apparently, he had painted his eyeballs over his eyes, and there were plastic hands that he was resting his chin on. He was sound asleep, and he got up, and the plastic hands were still. Do you remember that one? You guys remember that one? Anyway, don't do that when you're meeting with your client, okay? Empathize with them, know their case, because you can't be passionate, and you can't be precise in these arguments if you don't even know the facts of your case. So going back to our drug court thing there, is that a drug court argument that is very powerful is an argument that a person can get better treatment, Your Honor, than even what your drug court has, okay? And we'll get into those issues in a little bit later, but the state penitentiary system, you guys are aware of that, right? And the state penitentiary system, especially with mandatory DUIs, is something that we should avoid, right? Now, I'm going to step off camera again, and I'm warning our camera people because I have to retrieve a document. Now, again, how many people in here know that with DUIs, for the most part, the judge is not required, despite this length of the sentence, to send the person to the state penitentiary? How many people know that? He's not, okay? If you want to go into the statute for that, I'll give you a little bit of a reference here. Just go into Westlaw 8.1, choice of decision maker, 3815, mandatory sentencing, county supervision. This is a transcript. Remember we talked about sharing. This is a transcript, and Bruce was with me, from Lycoming County, where they're having a Little League World Series. Is that where Williamsport is at? Anyway, Lycoming County, where the defendant was already in treatment. I think it's very important. We'll get to that detail later, but the defendant was already in treatment, and we showed the judge that he's already in treatment, Your Honor. He's probably in treatment that's more aggressive than your treatment because he has this pharmacotherapy, and we don't think he should be sent to the state penitentiary, and the judge agreed over the vociferous objection of the district attorney and all the articles written about how their county is overcrowded and prisoners and whatnot. Now, if you don't know your client and if you don't know his case and facts, you can't make that argument. So it really was an easy argument to make. Number one, the judge has the power, if he wants to, not to send someone to state penitentiary. Number two, the district attorney was in the hearing talking about the overcrowding in that county and how much it cost the taxpayers there. I was the only one talking about the best chance of him not repeating alcohol is to get him treatment now. And so therefore, I have to win that argument. So these arguments are winnable if you make them. And many times, by the way, just knowing that you're going to make that argument, you can find a better deal. One time I lost this argument in Crawford County. And in Crawford County, what the judge did when it was all over, after telling me no, 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 he sentenced the guy to consecutive sentences and the concurrent issue. And he dressed it down so that we did get a significant break from it. So anyway, I'm going to put this back and walk off camera a second. And move on and tell you basically what we're doing is combining three basic things. And one of your documents there that says, that's this document, your handout here, it says, SH, by the way, that's the office we have. It's Independent Substance Abuse Network, ELM. ELM is Education, Legal, and Medical. The first thing we do is combine we already talked about knowing what you don't know, the educational component. We're talking about the legal component and the medical component, and they work together, okay? Now, this trilogy also expresses itself in that courtroom argument with another trilogy, and one would be law, one would be pharmacology, and one would be counseling or behavioral modification. We're going to go to this later. For now, I want to focus on this one. Behavioral medicine starts with a recognition that many times an addict or abuser is self-medicating, okay? That's a pretty complicated issue, and you'll hear some of the most gifted physicians, psychiatrists, psychologists, medical people from all over talk about how complicated that issue is. That's not a real easy criminal intent issue to walk away from. Now, alcoholism and addiction-related impairment is as old and goes as far back as the book of Proverbs in the Bible. If you looked at the book of Proverbs in the Bible, it talks about alcohol and drug usage. In all those years, okay, the only medical approach to alcoholism and addiction has been what? For the most part, talk therapy, right? Counseling. Alcoholics Anonymous. All those kind of fine things that are going on, it's talk therapy. Now, talk therapy is very effective and many times very ineffective. If I were standing up here talking to you, and those of you who are taking notes, I would ask you to observe me at the podium at this time, just because I want to make a point and keep on. Can't hear what I'm saying, right? Okay? Have you ever stood next to somebody with a jackhammer? What? You can't. An addict many times can't hear some of those most gifted phrases from those counselors because of the blinding effect of that compulsion that's wrapped around their core, their spirit, their heart, whatever you want to talk about. Many times, even the most gifted counselors can't make it. So if we only had counseling, do we recognize that maybe it won't be as effective? And the pharmacology is very important. Now let's go back to my beautiful little daughter, Annie. I will never forget one of the times she was playing softball and I was watching her and I heard some coach say, "Move in, nobody can hit it that far." I mean, you already know the end of this, right? And she steps out of the batter's box, and Annie is always accessorized to the hilt. She's not into the girly things, but she had eye black on. She actually got scolded by an official. I guess they're not allowed to pull it too far. Do you know that? There's a rule that you're not allowed to make your eye black come too far down your cheeks or something. She almost got thrown out of the game for that. Just for the heck of it, I wanted to make an argument, but I let it go. I didn't want to embarrass her. Anyway, She steps out of that box, steps back in. They're in a tournament. It's the last game of the tournament. They're down by 2 runs. She hits this ball so far and so high, it literally went over the concession stand to the next concession stand. And some lady, I'll never forget it, was standing there with this lime snow cone with her back turned. It hit her hand that had that snow cone, and all you saw was this flash of lime-colored stuff everywhere, and then it hit the glass like that movie, The Natural, you know, with Robert Redford. Remember when he broke the spotlights in the stadium? And I look back at her, and she's jogging around the bases, and the kids are... I have told that story 100 times, I'll bet, and I have goosebumps again as I'm telling it to you. What's the point in that? The point is, that got me high. Let's go back to poor Nancy Reagan. Just say no. Get high on life. Most of you are not alcoholics or addicts. Why? Because we do, in fact, it sounds corny, but it's the truth, we do get high on life. Something will happen to you today. Something will happen to you later today that you had no thought that it was going to happen to you. You might walk into court someday and you're really down, and all at once you run into somebody or something. Something will happen to you. Each day has little nuggets built in it that actually pick us up and help us when we feel good about who we are, what we just did in court or something. Something exciting happens. They can't feel that because of that compulsion that's wrapped around them, around their soul and their spirit, that white noise, right, that prevents good things from getting through to them. Okay? So when you take this pharmacology now, let's go back to that pharmacology we were talking about. Now, I am not a salesman of naltrexone, Rivia, Vivitrol, or any of these products. I would never accept any enumeration, even for speaking on behalf of what they're doing. All I know is I'm trying to be a good lawyer, and I know it works. Okay? And if I know something works, even though nobody else in that courtroom knows it, including the judge, I'm going to make it part of what I'm doing. So if I get somebody with a pharmacological intervention that now allows those things that get most people high, allows those words of counseling to get in there, then I have done something good, and the legal system has caused that. Now let's go back to our numbers, right? Our numbers are 1.6 million people a year arrested. Of course, the Attorney General will stop doing that, so maybe that number will drop, but hopefully he's not going to wipe out my argument here. But if we know 1.6 million people a year get arrested for substance abuse, and we know that 37% of them seek help from criminal justice, we know there's 594,000 motivated people out there. Are they motivated for the wrong reason, maybe? Probably. They're only doing it because they don't want to go to jail. Duh. Okay. It doesn't matter. We have to reach out and save them. Okay? So if we know we have in the criminal justice system 594,000 annual cases, and we can get them into good therapy, which would include a pharmacological intervention and counseling now that will start to work, haven't we begun to do something positive? And at the same time, we're dealing with the legal problem too, aren't we? Well, let's talk about that. First of all, I want to close one gap on this system. And Mr. Ludovisi, if I went over here, can you still catch this in the camera? Or I'll erase this if you want and just start back here. Better to erase. Yeah, I don't want you to have to move. Okay. That's my addict or alcoholic, okay? He's a person, she's a person with a frown. She should, he should have a frown. She has a legal problem that could put them in jail. In the world of problems, you all walked in here with problems just like I did today. In the world of problems, that's a pretty big problem, right? A legal problem is not something that you just ignore. A person also has a health problem too, don't they? Now that we know a little bit more, now that we know what we don't know, this person has a huge health problem. At the same time, closing in on them, okay? So, it amazes me. Again, a good lawyer, I think, is going to say, I'm going to try to fix both problems. Now, I'm not saying a bad lawyer does it differently. I'm merely saying if you want to be a better lawyer, what a good lawyer would do. It's to me, what a good lawyer would do is not focus all of their efforts here. Because if you're a good lawyer and you find some really hot suppression issue, and you're going out there and, man, you're king of the roost, and the district attorney knows it, and the judge says, I'm sorry, you had no probable cause for that stop. Every single thing that you obtained from that stop is dismissed. Okay? This guy, lady, or whatever, big smile on her face, legal is gone, still has a health problem. What are we afraid of? Killing themselves or someone else. Maybe even more emboldened now than ever before. Have we really done something for that person? No, hey, they're going to put my name in the law review. The Tribune Review asked me, there were cameras flashing, everything when I was coming out of the Allegheny County Courthouse. Man, they think I'm really a good, sharp lawyer. Are you? I don't know. That's your call. That's who you are or what you are, you know. Are you a good lawyer? I don't know. All I know is that if I did this, I think I'd be a better lawyer. So how would that work? Okay. We know that sometimes if we copy successful people, it'll make us successful. I'm the biggest copycat there is. You show me something that works, and man, I'm all over it. Send me a Word document, so I cut and paste it. I don't care. I'll footnote it. I'll make sure you get the credit. I want to take as many shortcuts as I can. Because I'm 63 now, and I'm watching this big ticker tick off here, and I got a heck of a lot less seconds than I used to have on the other side. And I don't know how much longer I'm going to be here. I want to do something. So, on that health problem and legal problem, if I'm copying successful people, I'm also a student of history, as I said to you before the class started. Love to read history. Anybody ever read about John Davidson Rockefeller? John Davidson Rockefeller was one of the most wealthy people in America. We know that, right? All that happened later, all the charitable work he did and everything. He started out as a little accountant making accounting salary. He got involved in petroleum, back when petroleum was called devil's grease, okay? Usually people who become successful saw something that no one else has seen yet, okay? So if you're sitting here saying, boy, I never heard about that Vivitrol stuff or about injectable blockades and all that stuff like that. Well, maybe it's a good thing you want to pick up because now you're getting something on the ground floor or something. But John Davidson Rockefeller lived in a time when there was no industrial revolution, there were no cars, right? If you wanted to become famous as a kid, you couldn't go and become a pitcher for the Mets or for the Pirates or something like that. Basically, the best way you became wealthy and famous and took that quick, fat ascent, you found salt. Because salt was important for everything. There was no refrigeration. So you run around all over the place digging in the ground looking for salt. Anybody ever go to Cleveland? Cleveland? Okay. The Flats, right? You know where the Flats are? I know. There was a kind of exciting. I had a case up there once representing somebody who had a nightclub. I don't want to clutter my tape here, but we'll talk about that some other time. But anyway, the Flats, very, very huge salt supplies there. And or else you dug water and there was seawater trapped that you would boil and boil it down to salt. You would become wealthy. So whenever they would drill and they would hit this black stuff and it ruined their well, they used to call it devil's grease. They used to throw gasoline on the French Creek up in Titusville and throw it away. When they first were harvesting petroleum, they would do it with blankets off the top of the creek and wring out the petroleum. That's when John Davidson Rockefeller saw something that no one else did. They were making all light, basically. It was more about light than it was lubricants or cars. And back then they were using, whale oil and things like that for light, and this allowed us to get into kerosene and all that stuff. So he saw that, and he went up there and got involved and got himself positioned. But John Davidson Rockefeller, in the applicable sense here, always said to himself, if I have something that the other guy wants that I really don't want. I can do without. And he has something that I really want. And we traded. That is the beginning of a wonderful arrangement. So think about it now. Let's talk about the competing interests. Does anybody here remember in law school the class Conflicts of Law? I know you got a grumble on your face too, and it was kind of weird, but it was a neat case when you think about it. I kind of like learned so much about being a lawyer in that conflicts of law, because there are many conflicts that are only apparent conflicts and not conflicts at all. The neat thing I liked about Loeffler on conflicts of law, if you want to look this up, little skinny book, it's really kind of neat. He basically taught me a positive approach, that I'm going to look at all the things I agree on and work backward. And you'll be amazed at how many people you are in open conflict with, that a lot of items are there. You can make your judges very happy when you say, Your Honor, we're here, but I want to make sure the court knows that we're down to about 2 issues. We agree on this, we agree on that, we agree on this. They love that. And they should, because you're doing something good for the administration of justice. But anyway, let's take a look at who we got here. I didn't walk out. Am I okay? Okay. We have, over here, we have the prosecutor, and over here we have defense counsel, and over here we have the judge, and we have the defendant, okay? The defendant doesn't want to go to jail, okay? Make it simple. The defense counsel wants to make the defendant happy. The prosecutor wants him to go to jail. Wrong. See how you're starting to drift now? The prosecutor really maybe doesn't want him to be in jail so much as he wants him out of his face. Okay? That's another foul I have to do. And if I don't punish him, he'll be coming back. So more than wanting him in jail, the prosecutor doesn't want him around anymore, and neither does the judge. So if I show the judge that I'm going to do away with this health issue, which is going to reduce the recidivism or take away the possibility that he's coming back, we're starting to get to that point in time where we have less things that we disagree about and more things than we do agree about. Now, because this guy doesn't want to go to jail and he's finally going to man up or woman up, or whatever you want to call it, and deal with the problem, we now have the ability to get them help, pharmacotherapy, and counseling coordinated together, and we have now taken the properly motivated patient and put them into the most aggressive therapy, and haven't we made everybody happy? And they do, okay? Now, I want to go back to that research. It's very important. The compelling research in the compelling objections from these people, these brilliant people who have written this, the compelling objectives or objections that they have about drugs as they are presently constituted. They're not against drug courts. They believe drug courts, even as they're constituted, is better than locking them up, and I agree. But as they are presently constituted, they could be made better. How could they be made better? Okay. When I go into court, I want to make the T argument, treatment, right? We now know that that's probably a good thing, but it's also a dangerous thing. Let's take a look at the Attorney General's position we talked about earlier, saying we're not going to arrest people anymore. Okay, it's probably just as dangerous or maybe more dangerous to overreact to the treatment argument. And drug courts, as they are presently constituted, how many people in here know that how many people in here are in a county that has a drug court? I'm going to give you a little piece on that. We find 3 basically themes. 1, no drug court. 2, a drug court that's been abandoned. 3, a drug court. Okay. Almost none of them have a local health-centered approach. What is a local health-centered approach? Well, first of all, what the state penitentiary system is patently not a local health-centered approach. The one-size-fits-all. For example, the state penitentiary system in Pennsylvania, and most of them, do not allow pharmacotherapy. Now, we just talked about this, and let's talk a little bit more detail, by the way. This blockade. Here's kind of how it works. You have a receptor in your brain, and again, I'm not a doctor, okay? I'm parroting what doctors have taught me. We have all kind of resources. You can call a doctor and spend hours. You can go online and really see. Anyway, think of a satellite dish in your brain that receives or a satellite dish that receives trying to think of a popular show. What is it? Okay, for you conservatives, it's Fox News. For you other people, it's CNN, whatever. So we have Fox or CNN, depending on what your bent is politically, and it comes in there and you get to see it. In your brain, when it comes to alcohol or drugs, the receptors permit this receptor to be stimulated and reduce and release, endorphins into your body, which make you feel good. Those of you who eat too much, you probably are eating less for eating too much than more the good feeling that comes after you eat. And that's really a chemical reaction that's taking place in your brain. But anyway, when we have naltrexone, again, this is a doctor. When we have naltrexone, it sits on this receptor. It sits on this receptor and doesn't allow that stimulation, okay? And if it is in a pill form, it's a 24-hour deal. If it is in an implant form, surgical implant actually, it could be multiple years, 2 to 3 years. If it's an injection, it's 30 days, okay? So if we know for 30 days that chemically speaking a person can't, even if they ran into a buddy who took them to the bar and started drinking with them, can't get high for 30 days, or if they took opium and directed it right, and their body would not respond, that's a significant development. And courts, when that argument is presented and that evidence is shown, and we have even doctors who will appear and testify, they start to feel comfortable that we are now stopping recidivism. So now a probationary order only need say that the person will be in his treatment and he will follow his treatment plan. And now it's not just some vague word treatment, it's treatment with the pharmacotherapy, the counseling that goes with it, and it's made binding by the law. It's made binding by the law. And the legal community has facilitated all of this. And the pharmacotherapist is working with the counselor. It's coordinated together. Do you understand that that's a compelling argument, especially if your defendant is already in it? Now, my style, when I have a defendant like that, I tell them, number one, there is absolutely no guarantee. I'm not a snake oil salesman. There is no guarantee that you're going to have any benefit from the criminal justice system. That's in writing everywhere. No guarantee at all. And there's no guarantee that you won't become re-addicted somehow. What we are saying is you're playing the best odds that you would have. And let's talk about that. Let's suppose somebody did this and they relapsed like 60 days later or something. Even in the worst case scenario, haven't we done something very compelling if we've shown them the way back if they wander off the reservation? And the answer to that is yes. We have done something a good lawyer would do. Secondly, they most often don't relapse, but If they did, we have already shown them that. We've shown them the way back to drug rehabilitation. So now, we have taken that legal problem and that health problem, and we actually make it a friend. If the legal problem and the health problem pass through each other and the defendant is lifted out of harm's way, we now have allowed both problems to become a barrier, a firewall around the person, so that that binding order of court that goes to the probationary order is going to keep them on the straight and narrow. And now, again, I think that's what a good lawyer would do. And that's the entire argument on that. Now, I want to give you a very important caveat. In the world of medical treatment, and again, I'm not a doctor, I'm giving you generalities here and encouraging you to do your due diligence. In the world of medical treatment, there appear to be limited options for an addict or an alcoholic. The one, what do most addicts or alcoholics do? Keep doing it, right? Dr. Raleigh Sullivan from University of West Virginia, who teaches with us, says, what's the favorite drug of an addict? More, okay? So most of them keep doing it, keep abusing. The second option is to do methadone. Anybody know what methadone is? Anybody heard stories about methadone? How many people think negatively about methadone? Most people do. Okay. Once upon a time it was, and by the way, it's probable that that's why the state penitentiary system doesn't allow pharmacotherapy in their system because of methadone. Methadone is very, very highly addicting. It's very highly addicting. There are stories, I'm a zoning lawyer too, there are stories where methadone clinics come to town and they're always resisted by the neighbors. As well, they should be. Not because they're being mean to people who have a health impairment, because the way they're constituted, for one thing, I guess, I don't know if it's still that way, correct me anybody out there that knows more up-to-date information, but you get more reimbursement if you travel farther to get your methadone. So that's still the way it is? Yeah, something like that in the welfare thing. Okay, so that encourages people from out of town to come to your town to get their methadone. Now, the craving that goes with drug addiction is usually on a 24-hour cycle or less. So they start to feel really bad very early in the morning, and they'll be lined up in a soup kitchen, like a soup kitchen outside that methadone thing. We're talking 6, 7 in the morning, and they almost all go there first. There are instances where people have been found to sell their dosage, saliva and all, to people on the street. Yeah. And that's, one of the other byproducts is for some reason it does terrible things to the enamel on your teeth. It'll literally, sometimes you see a really attractive young person that have major dental problems. It's almost always a methadone thing. Anyway, so that's one option. The second option, or the third option, is Suboxone. And Suboxone is, I kind of call that a fancier cousin. And again, I'm not a doctor, but Suboxone is an opiate, okay? And what it is it's not injected or it's not snorted, so therefore it goes through the digestive system and absorbs slower. You usually don't get a high from it. It will blunt the cravings, but you are still dependent on that. It is an addicting substance, okay? But hear of Suboxone, buprenorphine, combinations of both? Okay, there's many clinics all over, and they'll usually say, new treatment. That's what they're usually talking about, okay? The next option is pain management, okay? Pain management. People who get Vicodin from the doctor, because they have a bad back. People who had an operation and it went and they got addicted innocently and now they're stuck. Pain management abuse is a huge problem. Just for example, people who have their house on the real estate market, people who have young kids, people who have babysitters to come over or dog sitters. Be aware that sometimes, many times, the first place that person will go when unattended is to your bathroom, say, you have a bathroom? And they go right to the medicine cabinet and pick up anything that's in there. They'll read the label later. Huge problem. The kids are doing it. They all show up at somebody's house, and they all raid the medicine cabinets at home, and they go to a certain place, and they just start taking them. Huge problem. Real estate showings of houses and whatnot, major problem. There are people who scout the good neighborhoods all the time to see whose house has open house, right to the medicine cabinet, right to the bathroom. Yep. Anyway, pain management. And that's a problem for the doctors, too, because the doctors have people going, oh, my back's killing me. Subjective, right? Okay, here's some Vicodins for you and whatnot. So pain management is contributing huge amounts to this. Okay. And the fifth option, and I'm just going to call that the blockade. The blockade. That's the naltrexone. Again, I'm not a doctor, okay? And I'm using these words because I was taught these words, but I am not a doctor. But the blockade is that approach where you keep somebody from getting high to prevent drug and alcohol relapse. It's not addicting. Major difference between keep doing it, methadone, Suboxone, pain management, huge difference. But it's not without its warts also. The blockade is so effective that, think about this one now. We know the person is self-medicating, right? If a person is self-medicating, wouldn't that be a dangerous thing to no longer let them self-medicate? Isn't that possible, with suicide and things like that? So it's very, very important to know that that's a huge problem. And secondly, the other problem with the blockade is that you cannot administer the blockade if a person is still on opiates, pain medication, something like that. They would have to be clean or totally abstinent for about 7 to 10 days before they could get that application of medicinal. Pardon me? Because they clash. You have to be clean before the blockade will work. It actually would trip you into feeling like you're going into withdrawal. Again, I'm parroting what doctors have told me. By the way, if you want doctors, I have no problem giving you names and whatnot. Dr. Robert Woolhandler, Wilkins Avenue, Dr. Valerie Gilreath up in Meadville, Erie area, Dr. Raleigh Sullivan, West Virginia, Dr. Neil Capretta, Gateway Rehabilitation Center. And we have all kind of information like that for you if you want to know more. We have all these websites. And this injectable blockade, by the way, again, remember we have the pill, and we have the implant, and we have the injection. The injection is called Vivitrol, Vivitrol. You can Google that, Vivitrol, and it'll tell you all the things, And by the way, it has all those FDA warnings on there too, that are supposed to be given. The injection? The pill is called Revia, Revia. And again, there may be other brands now, but that's the one I remember working with a particular doctor. And there are implant sites. I think the nearest one is in Virginia, where they put it in actually under the skin, and it lasts for a couple of years, I think. But most people are shying away from that because that's pretty invasive, Okay. So, and we know, or we should know, that we need counseling. And again, let's go to the blockade. We now have prevented them from self-medicating, so isn't it more important than ever to search for and find the underlying root cause of the problem, at the same time? Because it doesn't happen in a vacuum. It's not just, let's keep them from getting high. So this is the most exciting part to me of the opportunity we have as lawyers. This is, it's like, if you're going to get excited about something today, I'm telling you, I am excited about this, and I'm getting goosebumps because this, to me, takes us to a whole new level. And when you get in front of Al Lindsay today at 2 o'clock and you hear about all the other famous lawyers who have really done something and what class of people you belong to, and you realize, and you take that now into this application, it's exciting to me. We already know that the legal community has an abundance of properly motivated people, right? And I'm not just talking criminal law, those huge numbers. I'm talking employment law, right? How many people have lost their jobs? How many people have been suspended or lost work or have what we call presenteeism, where they show up but they're not there and they're not productive? So the employment situation is just as, we also have situations where people have lost their legal license for practicing law, or you may lose your custody of your children. The legal community has an abundance of properly motivated people. Okay, now, the other major thing for the legal community is what makes me most excited, is that, remember now, these are all private businesses, and these are all medical philosophies, and each of them have their share of credibility. They are all accepted procedures. They are all accepted as medically sound, but some work and some don't in a particular case. And again, we're not doctors, but isn't it kind of neat if we worked with doctors who evaluated each case at a time and came up with a prescription that was individualized and sent it to you, like I get mine sometimes from the doctor in my cell phone as I'm standing waiting my turn to be sentenced, and print it and add it to a court order. So what other thing does the legal community add to it? We add the inherent neutrality of what we do. Everything we do is neutral. Everything we do must be in document form and that document must be sent to the opponent of that idea, and that opponent of the idea has the ability to go to court and argue against it. Who better than the legal community could bridge this gap between all these competing philosophies and whatnot, and all these competing interests? Nobody is the answer to that question. And you know what? If we really want to get a solution, what better solution is there than the anvil of litigation? I love that phrase. The anvil of litigation is when I go into court, and you know what I tell people? People talk about, I hate to throw in these personal things, but it's kind of, you have to have a little bit of fun with this. How many people in here ever played sports? Ever played football before in here? In high school or college or something? Do you remember we used to call people dummy scrimmage heroes? There's always a guy that won't hit anybody, that you could tape raw eggs on his shoulder pads, and at the end of a week, they won't be broken, okay? But when it comes to the night before the game, when nobody has pads on, he wants the coach to put him in tomorrow, so he's running like crazy and diving, and he hurts somebody. I call that a dummy scrimmage hero. We have people who go into motion court, right, when nobody is there to oppose it, and they make big speeches, and they got citations for the judge. To me, that's phony. That's a dummy scrimmage hero, okay? That's a person who's just without substance over here. So in the anvil of litigation, though, you go there and you know there's going to be a prosecutor looking to shoot holes. And by the way, that transcript I was showing you from Lycoming County, and I'll gladly email it to you. My defendant has given me permission to do that for educational purposes. It's really neat where the judge says, Mr. Blank, I'm not going to say his name, you just want to punish the guy, right? Well, yeah. I mean, what have we gained by that? So again, when you have the anvil of litigation, when you have that pushback, isn't that the best way to make sure that somebody like me isn't underreacting to a problem? And that legal community that provides that forum where all of the competing interests come, aren't we going to produce a better piece of law than some legislators that are basically getting some kind of, huge financial contribution for some nonprofit group that has a real thing for, let's put everybody in jail or something like that. Or the other way too, let's not put anybody in jail. Everybody has their own problems, and this is, so that to me is the most exciting part, where the anvil of litigation can produce a prescribed, all of these people working together, local, health-centered solution that you can walk into court and lay it on the judge's desk. And by the way, the things that we share and are available, we have cut and paste orders and everything. We've done it, some of you people, I have one that I submitted to. Judge Mackin was kind of neat in Allegheny County because he's a doctor and a lawyer, and he understands medical applications. So again, going back to that legal community, providing an exciting place for us to have a role, and maybe the most important role in this whole thing, because ours is neutral. Now, this assessment process where you arrive at this prescription is very important that that be neutral too. And you all heard about the CRIN evaluation and the assessment for drug and alcohol and all that, and they're all well and good, hundreds and hundreds of them all over the place. But I respectfully submit that a real assessment is one that has salient findings and then defense treatment recommendations that are neutral, not beholding to anybody. I think it's very important to have an assessment from somebody who's not going to be in the treatment team, because aren't you just creating your own client base? You know? And doesn't that happen up here in Suboxone a lot? Or up here in Methadone? Oh, she's been coming here for 3 years now. Duh. 3 years, they get, if you ever challenge somebody in custody or something like that, and you got somebody that walks in and says, "Don't bother me, I'm in treatment," you ask them to you subpoena their records, and you ask them to show you how many milligrams they're taking today compared to how many milligrams 2 years ago, and you'll be shocked to find probably more and very likely not less. Never buy into that treatment argument without demanding to know how many milligrams you're on right now. When's your doctor expect you to move off? Do you have a goal toward total abstinence? Or I'm just going to be forever a methadone addict. Or I'm going to be forever a Suboxone addict. That's the kind of pushback that comes in a courtroom with advocacy, and that's the kind of things that'll make a difference one case at a time. And that's what we're advocating here. I need to take a look at my time here, and I'm showing at 9:03. Is that about right? Okay, good. And again, because we're going to be pushing straight through, you do not offend me by, if you have to run to the restroom or something, go ahead. And I would remind everybody, too, that there's stuff in the backpack here. I teach sometimes in places where they don't have it, but apparently they have bagels back there and coffee and all that stuff. Okay, so again, summarizing, let's go into the behavioral medicine issue, the counseling. Simultaneous search for and holistic treatment of the underlying root cause. 2, pharmacotherapy should never be used without counseling that is coordinated for obvious reasons. Neutral, holistic, specific treatment findings and recommendations should be incorporated into a comprehensive, individually prescribed, specific, enforceable, legally binding, immediate, intermediate, and long-range treatment extended care plan. That fits under the behavioral medicine counseling part of our trilogy. Pharmacotherapy. By the way, this is a 3-legged footstool. If you saw a leg off a 3-legged footstool, what happens? It's no longer a stool, right? You've got to have all 3 legs here. The second leg of the 3-legged footstool is the pharmacotherapy. Total abstinence, okay? That's what we're talking down here with the blockade. Total abstinence. Nobody is on an addicting medication of any kind, legal or otherwise. Non-addicting medication, most effective medical intervention, and certainly it's not for everybody, but it should be at least a goal. When I taught school, I coached football too, and I used to stand, and I started out coaching junior high football. And I remember I would stand in the doorway the first day of school, which we're all approaching now. And if somebody's head hit my arm, I said, "I need to talk to you. I want you to play football." So they all come in the doorway, and the numbers that are supposedly valid is that 2% would probably be special needs, 2% would probably be gifted, and the vast majority are in the middle. And when you teach school and you have to reach 35 kids or whatever, you have to have something for everyone. So in the total abstinence, I kind of think of that in terms of like the ultimate goal. In sports, if you want to use that kind of a analysis, you could play football in the public school system once every other week in gym class. Or you could be on an intramural team and not have to practice every night, but you could play competitively maybe once a week. Or you could be in the highest form, which would be interscholastic competition, where you're going to go to do 2-a-days or 3-a-days now. I think they probably even start this week, don't they? Anyway, they'll be doing that, and then they'll be competing with other schools in the highest level. So again, I think total abstinence is certainly that should be part of their curriculum. I don't think anybody should be selling a treatment plan to anybody without saying, what is my goal toward total abstinence? I mean, don't even talk about it from what I hear. Okay, total abstinence medical intervention is not possible without some type of a detox. Remember we talked about that, where you have to be off of something for 7 to 10 days. So it does, as we said, have its warts too, which most often follows a painless but aggressively progressive application of other pharmacotherapy. Again, what's that message in that? If we have somebody working together, that helps. And total abstinence pharmacotherapy should not be administered unless it is administered with coordinated counseling, just because it is so effective. Now, the third leg of the three-legged footstool is the law. And again, I think it's important for you to think like John Davidson Rockefeller and find out who the decision maker is. We have the DA, the authority figure. We have the adult probation, the court, the employer, the school, professional licensing board, etc. The legal community provides the most motivated patients to the medical community through all those avenues. The legal community provides the forum and record for all competing interests to be heard and accounted for on the traditional anvil of litigation. And I'm going to say that over and over again, anvil of litigation, which means pushback, which means accountability, which means the best concept will surface. And it might not be coming from me right now. It might come from somewhere else. But it is important. It is as important as this idea that you be competent and you know what you don't know. And then your next level is to at least know there's something I don't know. The next level is I still don't know it, but I know part of it. And the third level, next level, is to know it inside and out and stay on board with the latest developments in facts and research. The legal community also provides the medical neutrality for assessing all the competing interests, and then secures a treatment plan that is evidence-based of compliance. Now, how does that work? Some ethical issues here, by the way. You may or may not have a client who's going to fit this mold. I'm merely telling you what I have found in 30 years I've been doing this. I remember when I had a 2-page retainer agreement. I think it's like 20 pages now. It might be more. Those are all paragraphs of things that happened to me or people who have disappointed me. And I found ways to make sure we get that out of there. But there's some major things that happen when I decide to represent somebody who has a substance problem. The first thing is that I don't want to represent somebody who has a substance problem. I want to be their treatment counsel. I do not want to be their legal counsel. And I'll explain to you why. But however, if they have no legal counsel, and because it's so new, it's many times I'm doing both. But I make sure that we have this ethical contract. First of all, I require them to sign a contract of representation with me that includes a statement that your health interest is more important than your freedom interest. They're both important, and I'm going to do my best for you, but your health interest is more important than your freedom interest. Well, that's kind of a mouthful. How does that work? I'll give you a story, a real-life application. It happened in Allegheny County. I had a case years ago, it was in December, I remember, where a mother knew what I was doing and said, her son's really out of control and he's doing everything, but he's finally in jail. And I said, great, because he's safer there. He really is. And I said, if you really want my help, I'm going to go see him, and I'm going to find out if I want the case. This is by invitation only, mine, not yours. And I went there. Very attractive kid. He could have been a movie star. He had that Robert Redford look, you know, and he was really an athletic build and all that. He's a nice kid. He had a wonderful mother and I think a decent father. They were divorced. And I sat there and talked with him in the jail, and I said, okay, here's the deal. I said, I need you to tell me that your life is more important than getting out of this jail. And I know I already told you what answer I need, but I'm here to go eyeball to eyeball with you. You know, eyes are the mirrors of the soul, they say. And I want you to tell me, and then you're going to sign paperwork with lots of people around. It's informed consent, you know, all that stuff. And I want you to tell me that it is. And I said, in addition, I want you to tell me that there's a line on here that not only authorizes me, but directs me to notify the authorities at any time when I reasonably suspect that you are either relapsing, or show evidence of what we call precursors toward relapse. You start missing appointments and start showing up late and start not doing the various things. And you have to sign this ethical agreement, and your mother has to sign it, and I make them watch a 20-minute video. I don't even think it's 20 minutes. How long is our video now? It's about an hour and 20 minutes, isn't it, Bruce? And I make them watch that, and then they sign a piece of paper that they watched it, and all these terms are agreeable. And by the way, they do agree. I've rarely had anybody that not. I actually had one. I had one about 2 months ago, and we parted ways, and I think he's still in jail, but whatever. We're not for everybody. Anyway, so we're telling the DA and we're telling the government that we have auto self-reporting, policing of our own thing here. And think about it. Now, hold on. Let me ask you this. I'm going to build this backwards. If you represent somebody and you're doing both treatment and legal counsel, and you hear that they have relapsed, and you called adult probation or a policeman and had them picked up, would that scare you? But it shouldn't. If you really think about it, even without telling you what I'm telling you. If you report the person to adult probation, I am telling you it'll be much more lenient for them than they're going to find out. There's no way. Plus, this person can kill somebody, can't they, or die of an overdose? So I'm going the other way, though. I make them sign everything. So, but going back to my story, the kid said yes, and I knew he meant it. And they because they were going through a divorce, they were doing that thing where my lawyer's smarter than yours. And he had a lawyer that was smarter than me. I need to do all that stuff. What the heck's the matter with you? My lawyer says he can be down there and bond him out in 10 minutes. And he did. And 13 days later, he was dead. Just like that. I mean, I don't even think it was 13 days. Yeah, just overdosed and died. Because he was out, skipped all that part. On my plan, he was supposed to go out, and he was going directly to an addiction doctor, and he was going to be injected. If the doctor thought that was going to be. And we probably still have him now. He'd probably be working, maybe even standing up here lecturing with me to you guys. 13 days after he was bonded out, he's gone. And her picture has been on the paper in Pittsburgh. You could see this beautiful lady. She runs a treatment clinic. It shows her kneeling on his grave, putting flowers on there. You know, she teaches with me sometimes. I have her on video. That's just what happened. So I'm not ashamed at all that I'm going to rat you out if I think that you're, because guess what? If I'm wrong, they're going to find out that I'm wrong, and they're not going to detain him. They're going to let him out. And quite frankly, we have respect from adult probation and district attorneys and people because we're serious about that. So anyway, that is the ethical issues you definitely need to address And now we have the assessment. The findings and treatment / defense recommendations. You know, you can talk to me about assessments all day long, but I want someone to sign it under the penalty of perjury with their professional degree saying that these are the findings I have made. Because why? Because those findings are almost always going to be accurate. And people can differ on what treatment strategies, but I think if you have written findings, it's going to help these medical professionals not ignore that and get to recommendations that are applicable to those findings. So the assessment should be followed by or include salient findings and salient treatment / defense recommendations. It's what I do in my office all day long when it comes to any type of case, divorce or otherwise. When I am not being Benny Hill, okay, I have my little smart pen out. You know what a smart pen is? How many people in here have a smart pen? Nobody has a smart pen. Oh, you got to go get a smart pen. I'm going to send you all the Staples today. A smart pen is a pen. Duh. It's also a pen that has you plug it into your computer. And when you're talking, it will record everything. Now, you have to tell them you turned your pen on. But a smart, anybody in here have people that became clients that didn't tell you everything or lied to you in the initial interview? No, that doesn't happen, right? The smart pen, you tell them, listen, and I always tell them, I can't write this fast. I'm not going to write this fast. I'm turning my pen on. And what you do is you take notes, and the pen, it's very, very accurate, records everything you're talking about, and you take the outline, then you plug it into the computer, and you watch this little thing go like this back and forth on your screen, and a little window comes up, file transferred. And now you have all those notes. You can watch it on your screen, watch your hand go, and you watch it go right into the notes, and the audio that goes with it, you just file it. You can email it to people or whatever, and I always use a smart pen and interview my clients. And it's a great way to not have to retype any of that stuff, and it's a great way to conduct your interview. So I got $110 at Staples. Light Scribe, I think they might call it. Light Scribe or something like that. But the other day, my first one broke, and I had to go buy a new one. That's why I know how much they cost. I think it was like $110. So anyway, I'm doing my interview with my smart pen, and I make legal findings. Now, it's not like pages and pages. It's usually about 10 or 12 things. Person presented himself with a DUI. This is his 5th overall. This is, by the way, that was the Lycoming guy. This is his 5th overall, and this is his 4th in 10 years. And he's in state penitentiary getting naltrexone instead of, and he's work release eligible and everything because the judge had courage enough to do that. Of course, he really didn't have an option because the district attorney didn't make an argument that could reverse that. Anyway, so the salient findings are those types of things. And then you go down and say, if he were my client, it's my opinion that these are the things that should happen. And then you send the person off, and they got something. They have something valuable. So my consultations are always free, one only, okay, because that's a lot of work. And that's a lot of something else, too. By putting your name on the line that these are the things you find that be relevant and these are the recommendations you would make, I think that's a pretty darn good consultation, And that's what I do. And I can't tell you how many times people have left my office and didn't hire me, might come back 2 years later with those notes and say, I liked what you said, I just couldn't afford you at the time or something. Or somebody else took the file and they didn't do any of what you were going to do and I wish you had, all that, So that's that assessment process, which is very important. Now, once we have that, then we route these people and their file to qualified experts, not somebody up here who has a law degree who's telling you what naltrexone is and brain receptors and implants and whatnot. I'm merely telling you what a doctor said, but it's very important to send them, refer that file, including those salient findings, to a professional. In our case, we have professionals that we have teamed up with. Now we're starting to actually grow geographically. So one of the things we help people with is if you need a professional in a certain area, we do that. But we send them to counselors and case managers who now get them in front of a doctor, and we do have what we call a behavioral modification contract, okay? I'm going to steal some. How many people are coming back this afternoon? Okay. Please don't tell Al I did this, okay? He'll be highly offended. He's like very showy and everything. He's neat, but he's kind of temperamental. I think he's an artist, you know, or something. You know him well, it looks like, right? Yeah, he's kind of on the pompous side sometimes. He's very good, though. I'm just teasing. He's a good friend of ours. I would trust him with my kids. But anyway, one of his favorite stories, and I'm ruining one, so please pretend you like it. Okay, how many people in here know the most popular song in America, in American history? More royalties, you know because you're with me. More royalties than any song ever. Now, one of the reasons I like to relax your brain a little bit, you know, and so we're going to play with this a little while, just to have some fun. You need to guess. I need to have some people help me and make some guesses here. Give me a guess, anybody.
Happy birthday song?
Oh, Tony, you got it already. That's it. It's Happy Birthday. It's kind of fun to watch generational issues. You know, who would you have guessed? What's your favorite music? All right, there you go. Okay. Somebody else would be like me, the Temptations, you know, Motown or something. Oh, that was my phone. Motown or something like that, or the Marvelettes or something. But it's rare that somebody guessed it right away. But that's exactly what it is. That's why when you go in Chi-Chi's, they go, happy, happy, happy birthday, and they got sombreros and all that. They do not sing Happy Birthday the traditional way, because if they did, they'd have to pay royalties. You're not allowed. It's copyrighted. So what's the point of that? The point is that you already knew that. You just didn't know you knew it, right? I mean, you know it now that I said it. Yeah, it does make sense. Okay. So the behavioral modification contract is a contract of things that you already know are important for you to do. How many people in here work or have ever worked in contract law? A good contract is never seen again usually, right? A contract is just to remind everybody what you agreed to, mostly. So a good behavioral modification contract is to remind a person of things they know. And the big points, the highlights of our behavioral modification contract. By the way, it is 101 paragraphs now. Now you try writing 101 paragraphs about cognitive issues that are enforceable or even measurable in a court of law. That's a labor of love. It's taken us many years to do that. But among the things that a behavioral modification contract should have, okay, and you're saying I agree to this, I'm going to get some help here because I always come up with a new idea when I have a class. I'm going to give you some of mine, and then you can be thinking in terms of something else you would want to add in. Number one, we definitely want a restriction on who you hang out with, right? If a person looks like a duck, walks like a duck, quacks like a duck, and is seen in the presence of ducks, he's usually a duck, okay? So we want them to no longer hang out with addicts or alcoholics. Sound good? Yes, it is, and it's very important. Zero tolerance on that. Also, you should be working. Now, this injection here is outpatient, okay, and it works. Now, I want you to think of tiny little police cars floating around in the bloodstream of that person for 30 days so that even if they took a beer or even if they took opiates or whatever, their body wouldn't respond. That person is probably have some of the most productive work days he's ever had. Bruce was there one time. We had a guy come back, and remember that guy told us within seconds he felt the difference. That grip wasn't, on him. Although I hear that the injection hurts because it's a deep muscle injection for the time release thing. Anyway, so the behavioral modification contract requires a person to work, be a student, or be looking for work. We have a job search requirement in there, okay? Because they need to pay for their own treatment. I was a C student in undergraduate school. I was an A student when I went for my master's degree in school administration. I was an A student in law school, and I just realized a few years ago it's because I was paying for it. It's amazing how you treat things differently like that, but they have to have a stake, or what people say, some skin in the game, okay? Other things the behavioral modification contract requires that you keep all your appointments, that whatever the prescription and medical plan is, that it is followed specifically. Other things in behavioral modification contract that you check in regularly, that we have the auto reporting in there. Anybody else? Can anybody else think of something you would want to put in a contract that you want to make sure a person does, because we're rehabilitating the whole total, this is a full court press now. And if I go back to my educational days, for a while, I actually taught gym class, okay? And I learned that in gym class, I was teaching mental concepts through the physical. And many times when I coached football, before I put the kids on the field, I would sit them down in a classroom and show them on a blackboard what they were going to be doing. For example, you guys are now all into football, right? Some of you. To me, and I'm an old defensive coach. I love to play defense. We always play defense. People didn't score on us, but you got to score too. You can't win if you don't put points on the board. But one of the neatest little plays. Wow, I lost a whole tip on that one. One of the neatest little plays, and we're still in the fun range of our class right now, by the way. One of the neatest little plays was, imagine this will be the center, and this will be the guard, and the tackle, and the tight end, and maybe even a split receiver over here. We've got a quarterback and a halfback. Okay. I didn't put the rest of the players up there, because they're not important yet. You know, I even called them and asked them to please make sure I have dry erasers, dry erase pens or whatever that work. Anyway, so if you have a defender here and a linebacker here and somebody else here, a tackle and an end, if you double team right here, and this guy takes a misdirection step and comes back here, and this guy screen blocks here, and the safety gets over here in front of a defensive back, that guy's in the end zone, he goes for a touchdown. Did you ever watch a play and all at once somebody springs out of the middle of the formation and they're running like crazy? That's usually what happens, called a trap play. Okay, so I used to show the kids, this is complicated to do in real life, on the field, physically. It looks kind of neat, but it requires this guy to step with the right foot and all that stuff. But I used to put them in a classroom and show them that that's what we're going to learn to do today. And I can tell you, it is significantly easier to get them to physically do that once you mentally put the blueprint in their head. So my point is that through the physical, you teach mental concepts. Through the mental, you teach physical concepts. They're a total human being. So a total human being, this behavioral modification contract, or this process that we're going through, should be all of the major components. And that would include, physical. That would include mental. It would include emotional. It would include social, it would include vocational, educational, and this is me talking, spiritual. I tell people all the time, I'm not telling you you have to believe anything. I have a constitutional right to say what I believe. All I know is that even if it's hooey, it works for me. So whatever works, you want to marshal every resources all the resources you have to win the objective. So if you now have some kind of a plan in which you're going to be physically, mentally, emotionally, socially, vocationally, educationally, and spiritually working toward one goal, that's what we call holistic, right? That's everything. So the behavioral modification contract should have, and it does, have all of that stuff in there. And again, it's one of those things where you don't have to worry about it because we have one and we use them. Judges like that when you walk in and have some kind of an offer for the judge. One of the other things we require our defendants to do if they're in a program like this is to agree to go in right now, what we call early intervention. We always show up, unless it already happened without us, at the preliminary arraignment. What happens at the preliminary arraignment, criminal lawyers, that would be important to us here? Anybody? On? Thank you, okay? And we know many times it's ROR, right? And although there's no money, there are what? Conditions. There are conditions, right? Restrictions. So we actually walk in with a preliminary treatment plan as part of their bond. So that if necessary, even before they're adjudicated or pled or whatever, or tried to victory even on the other side, the bond condition is already in place. The bond condition is already in place to to enforce the treatment plan as early as possible. That young man, I think, was kept in county lockup instead of going to the state penitentiary because he already was a patient, okay? He already was in approach therapy. Now, isn't that a stronger legal argument if I tell the judge, Your Honor, if you take my guy and put him in the state penitentiary, you are cutting him off of his medication and you're cutting him out of his doctor's life, and he is in treatment right now. That's what we do. Now, is that good legal strategy? Absolutely. But it's also good medical strategy. See, they can work together, and they do. And again, that's what a good lawyer does, I think. A good lawyer plays all the cards that you can and does everything that you can and throw every punch that you can. And we see this all the time. On an optimistic note, defendants are people. And I can tell you this, I've even met people who I knew were criminals, but I think everybody has a decent side to them. Here's the way I look at it. Aren't we many times a sum total of the choices we have made? And those choices, by the way, sometimes come at us quickly. Sometimes they come at us when we're not thinking clearly. Sometimes we just make mistakes. Sometimes we're just wrong and we know it's wrong and we just decided to do something wrong. They're not good choices. But that doesn't mean they have to be a cascade of choices that follow after that. So, Abraham Lincoln talked about that in one of his speeches when he talked about the better angels in us, that hopefully there won't be civil war. The better angels will reach into who we are, and we will remember that our brothers and sisters are in the same fireplace sometimes, hearthside. We all live in the same restrictions and problems and whatnot, and we appeal to our better angels. So if we recognize that a person is not necessarily so much bad as he is a collection of bad choices that seem to get worse as it goes. That's one of the reasons why we have in our law office the concept that we will take a hit. No man, again Lincoln, no man has a good enough memory to be a successful liar. Isn't that a great, isn't even like a weird little lie an example of how things get out away from you? And then you lie to cover the first lie, and you lie to cover the third lie, and lie to cover the fourth lie. I mean, I actually saw a gentleman disbarred once where he was supposed to file a suit, and he didn't. And the guy used to call him all the time and said, "Did you file it?" And he kept saying, "Yes, I did, yes, I did, yes, I did." And of course, you know how this comes out. The statute of limitations runs, and the guy calls you a couple of years later and says, "How's my suit coming?" "Oh, it's coming pretty good." "Well, gee, I haven't heard anything." "Yeah, in fact, we settled it." The guy actually told him he settled it. He went and got a loan and sent him some money and said that's what he settled it for. Disbarred, no more practicing law. It's over, And that goes back to that idea that you own up to something when you make a mistake. It's a heck of a lot easier. But that's an example of a bad angel that takes over, and then you're trapped in that, and you can't go back, So, when you add drugs to it, too, something that has... And by the way, I am told that addicts, when they don't have an addicting substance given to them within 24 hours, in the lightest form of withdrawal, feel like they have the flu, no energy, every body achy, eyes burned, and all that stuff like that. In the most violent, of course, they feel like they have knives sticking in them constantly. So if you add all of those things together, it's important for us to recognize that maybe less than evil, there's nothing more than bad choices which were which were highly affected by this physical compulsion. Okay. Now I'm going to read you another Lincoln-esque thing here. This is Lincoln on February 22nd, 1842, long before Abraham Lincoln would have any idea that his birthday would be just as important. As a tribute to George Washington, bless you, birthday, he delivered a speech to Springfield Temperance Society, which says addresses this concept. And I'm going to read to you, even though I told you I wouldn't read to you, because Lincoln's words are certainly more moving than mine. And again, it is so easy and so common to ascribe motives to men of these classes, he's talking about drunkards, other than those they profess to act upon. The preacher, it is said, advocates temperance because he is a fanatic. The lawyer, from his pride and vanity of hearing himself speak. The hired agent, for his salary. But when one who has long been known as a victim of intemperance bursts the fetters that have bound him and appears before his neighbors, clothed and in his right mind, a redeemed specimen of long-lost humanity, and stands up with tears of joy trembling in his eyes to tell of the miseries once endured, now to be endured no more forever, of his once naked, starving children, now clad and fed comfortably, of a wife long weighed down by woe, weeping and broken-hearted, now restored to health, happiness, and renewed affection, and how easily it is all done once it is resolved to be done. However simple his language, there is a logic and an eloquence in it that few with human feelings can resist. They cannot say he or she desires a union of church and state, for he is not a church member. They cannot say he is vain or hearing himself speak, for his whole demeanor shows he would gladly avoid speaking at all. They cannot say he speaks for pay, for he receives none, then asks for none. Nor can her sincerity in any way be doubted, or her sympathy for those he or she would persuade to initiate his or her example be denied. And that's Lincoln talking about somebody who has recovered from alcoholism. And that's in 1842. When there were no chemical interventions, there were no counselors out there, there was no high technology and whatever. So now that we have all of this, and we actually bring ourselves to the point in time where we are now facing a better war on drugs. Question, history fanatics. World War II. What do you think was the most important factor in World War II that led to the Allies winning? Anybody? What was the game changer?
The weather.
Okay. Anything else? What was the game changer?
American intervention.
Exactly. Right? And I'm sure you would have said that too, if you knew where I was going. Does anyone doubt that the American entry into World War II decided it? I mean, and if you read history, you can read all the... We're not people who like to go to war, okay? And we didn't want to go to war back then either. Roosevelt had a hard time. There are theorists out there, you know, there's conspiracy theorists that think that he set the Pacific Fleet up in Honolulu in Hawaii, you know, to make it happen or whatever. And I don't think there's any real strong evidence for that. But there's people out there who think that, and I don't want to, you know, I'm not taking a position on that. But all I'm saying is that people did not want to go to war. Hitler certainly didn't want us in the war. And he did a lot to try to keep us out of the war. It was very, very, very delicate with America. But America literally caused the difference. We've been fighting a war on drugs, what? With a missing ally, haven't we? Who's the most important person in the war on drugs? The defendant, the patient, right? Once it is resolved to be done, quoting Lincoln, 1842, once it is resolved to be done. The war on drugs started with, let's go arrest everybody and throw them in jail. They're all druggies and hippies. And we're going to stop for a battery issue or something. If we go back to all of the treatment options, we have the continued use, we have the meth, we have the Suboxone, we have the pain management, and then we have the 5. I'm just going to start calling it total abstinence, okay? Now, when a person is in the throes of addiction and abusing. And when a person is on methadone, and when a person is on Suboxone, and when a person is on pain management, certainly we know that this is hard to get a person off of wide open addiction. We know that. We know about the 24-hour site. But now we got a problem here that again goes back to this legal community, I think, being able to help. We have we have all these competing philosophies, but we have different professionals. The abilities or the desires or the talents or the motivations of these lawyers in this room here differ probably as much as the shoe sizes in this room. And we find that in human existence, and certainly with doctors and medical professionals. It's possible that there could be people out there who really want to bring a person to total abstinence to work a solution to the problem. It's possible that a person wants to but is not strong enough to do that. Do we know lawyers who tell clients what they want to hear rather than what they need to hear? Okay. Do we think maybe there's people in the profession, in the health profession, that would do the same thing? I mean, their intentions are good, but they're just not into that pushing, you know. That's where I go back to this anvil of litigation, where we get some force. That's where we go back to the problem with the person with the medical, with the child custody problem, the guy who's going to lose his medical practice, the guy who's about to go to jail. We have to have, there's other professionals out there who may, and hopefully there aren't too many of those, not want to help this person and merely want him to keep paying month after month after month after month. Because I can tell you right now, this person is closer toward rehabilitation who wants to stay on methadone than somebody who wants to abuse drugs. But the way doctors tell me, it's like sleeping with a cobra. You're one step away from going right back to where you were, and you're a long way from total abstinence. And they do develop a comfort level. We actually have some doctors, a doctor who taught with us in our drug summit that we did last January, who actually takes the respiration rate of his patients as he's dosing them down. He'll actually make them go longer and sit in his office for a couple hours to watch them go from that last point of methadone, for example, or Suboxone, and take respiration rates, much like you would be teaching a kid to run wind sprints when you're actually in sports, and you push them out of their comfort level, so that, because many times they may be manipulating you, or maybe genuinely afraid that I can't do this without doing this, you know, whatever. But a medical doctor that pushes them. We had a girl one time, just to share with you how the legal community can play a huge role in this. A girl came to me, and it was one of the first cases I had, way back in that time I was telling you about the guy who got arrested 3 times. We had a Thursday rule in our county, which meant that you had to enter a plea by Thursday, or that's bad. And by the way, every time I've been involved in those things, they always have another day you can enter it. But you can't do it in Crawford County. Be careful. Anyway, if they tell you have to have it in by a certain day, you must have it in. Anyway, but this girl had Thursday, and she's in my office on Wednesday. And she had 2 choices. She could go to trial and lose. It was a controlled buy, wired, everything, slam dunk. Or she could go to the state penitentiary, or she could plead guilty and go to the state penitentiary. Those were her 2 options. Go to state penitentiary for a lot of time, go to state penitentiary for a little bit of time. And so I was able, it was the beginning of what we were doing here, I was able to get the district attorney to grant me a continuance, which is never allowed on our Thursday rule. In that 2-week period, she went from 94 milligrams to 0 methadone milligrams in 2 weeks' time, and then she was administered the blockade.
Can I say something?
Yes.
Again, this is his personal stuff. I was away many years. I didn't see when this kid started all this. But it appeared that the mental health system and the doctors involved in all this stopped at methadone. And the only time he would stop, he would go to prison. Be out of prison, start over again. And he's just a hardcore addict. And the doctor told his parents, he's just an addicted personality, you'll never fix it. So just kind of give up. I mean, how do you get around something like that?
Well, and again, they're doctors and they know more than we do. We're only lawyers. But I think how you get around it is certainly saying what findings. Okay, yeah, I'm summarizing that. The question was, thank you, the question was that this person was on methadone and he would go to prison once in a while. And when he was in prison, he certainly wasn't on methadone. So we know he could do without it. We know that. But when he came out, he would immediately go back to methadone, right? And everything else. Obviously, again, that's sleeping with the cobra thing. You know, you're not that far away from illegal drugs if you're doing anything that's addicting. And when his doctor was approached, his doctor said that he has an addictive personality, which is a well-recognized medical condition, and there's nothing you can do about it. That is what it is. Okay, so clearly the possibilities are that the doctor's right. He knows more than we are. We're not doctors. But just like everything else, we probably should get a second opinion. And we certainly would want to see the salient findings that he made that made him conclude that instead of just writing it off, right? I want it in writing. And if you don't have it in writing, I respect your profession, knows more than I do, but I want to take it to somebody that's going to put it in writing, that this is a person who cannot be helped. Now, the jail thing, by the way, provides an interesting possibility. We once had a judge that was going to deputize one of our defendants' mother to take him directly from jail, directly to Wilkins Avenue to be injected. We have one right now that's in Gateway that will be injected while in Gateway before they come back on the street. And being in jail is a great way to, you know, there is work taking somebody off of wide open addiction, methadone, Suboxone, pain management, to total abstinence. But when they're in the jail, the government's done it for you. And they're now eligible for the blockade. Again, doctors, if they make that determination. But I'm merely saying a doctor would make that determination. But most often, they're very, very ripe to be injected. And I can tell you this now. I'm not so sure, you know, if a person was injected and no longer had cravings and no longer had things going for them and they were totally absent for several months and then they went back, I just don't know if I might not be sharing that doctor's opinion, although I'm not a doctor. But I think a person needs to go to total abstinence before you write them off, you know. So, now, we've had people in our office when we tell them, without sounding harsh or without sounding uncaring, that probably in 6 months you won't have an addict in your family anymore. Wow, does that mean it works? No, it means that if they choose to be an addict after you've eliminated the cravings and had them totally abstinent for 6 or 7 months and they went back, you probably can't save them, but at least you should move on. Your family should move on too. Isn't it really hard to move on when you don't think that they can't help themselves? That's hard, and that's what really pulls the rest of the family down into that codependency cycle and all that stuff like that, you know. So in many ways, it's actually a defining moment. And if you take away the cravings and if you take away the compulsion and you actually prevent them from getting high and they still abused, then that's probably a really, 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 really difficult case, but a lot of them don't. Now, there's a possibility, I guess you could be on the medication forever, and you're going to say, well, hasn't he exchanged one medication for another one? And technically speaking, I guess you'd be right, but except this medication is not addicting. And it doesn't get you high. It doesn't reward you. It allows you to work. It allows you to make money to pay for your own treatment. That's what it is.
You're talking about methadone?
No, I'm talking about the naltrexone injection, pill, or implant. Now, I am not casting stones at the methadone people, but I'm certainly not waving a flag in favor of the treatment either. Or the Suboxone people or pain management, because I'm not a doctor anyway. I'm just telling you what my experiences are. Again, working some of these little vignettes in here. Going back to what a good lawyer does. A good lawyer, I think, is neutral. A good lawyer leads rather than follows. There are many people out there, you're going to walk into some reunion or picnic over the next several days as summer ends and Labor Day, you probably don't even know it, but people respect you and people know who you are and know what you do. And with that comes maybe an obligation to lead rather than follow. It's never fun to lead. Sometimes you just want to sit back, you're beat, tired and whatnot. But there are times when again, what you know you owe. Going back to my historic metaphors, it's so important to involve the addict or the alcoholic in this alliance on this war. Because as we stated just before we took that little battery change break, the war on drugs started some 40 years ago, and it was designed to fight drug abuse at the supply level. Remember that? Bolivia and all these places and burning fields and stuff and Vietnam and napalm and all kind of stuff. Well, I think everybody has given up on fighting the war on drugs primarily. I mean, we're not going to fight it, but not primarily at the supply level. And then they started fighting at the demand level. And again, it is submitted that this fight at the demand level probably is unrealistic until we can empower the addict or the alcoholic to be a key member of that alliance. And with the application of the pharmacology and the coordinated counseling, and I'm talking all pharmacology now. I'm talking about methadone, Suboxone, pain management, total abstinence, coordinated with counseling. Now we have arrived somewhere where we have a meaningful war on the drugs and we have the addict as an empowered, vital member of this alliance. And it's very, 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 very important to do that. And as a lawyer, you can bring it to the courthouse in several ways. And one of the ways that you would bring it to the courthouse is at the preliminary arraignment. We already talked about that. And then the preliminary hearing, those conditions can be added to the bond at either place. And then we get into call to trial. Now let's talk about trial strategy and whatnot. We already talked about challenging drug court, right? And I'm not going to go back there. You understand that you're going to walk into court with a drug court and your client's going to qualify for that. But you need to understand that that drug court might not be as tough as you need to be for your client. So you might want to add extra conditions, including this pharmacotherapy, to the already in place drug court. The second thing you're going to have is you're going to have a drug court that says they don't want your person in. And you might have to fight over that one. And the next thing is you won't have any drug court at all. And so in all three cases, you need to argue the case on its merits. And you go back to your smart pen and the notes you took when you first met this person, and you read up that research and you know how to make a cogent treatment argument that's not just using the word treatment without substance to it because you've worked with doctors, okay? And there's plenty out there and we're glad we share that with you. Now, there's some trial strategy. One of the most important parts of criminal procedure is something that we all know how to do. It's called a continuance, okay? A continuance. And it's a continuance that actually becomes one of the most vital weapons in working this solution. First of all, a continuance, what? Doesn't prejudice anybody. A continuance usually is seen as somebody's lazy and they don't want him to get out, or he's just trying to stay away from going to jail or something. It's a delay tactic. The bottom line is, if you got a continuance, and we've had magistrates in Allegheny County that have actually given us continuances and we got somebody in treatment, and I actually had a case where a person was in treatment for so long that the magistrate and the policeman actually withdrew the charges at the magistrate level. It never went downtown. There was multiple continuances, almost a whole year. And the person not only was in treatment, but proved that they were functioning in treatment. So there's some creative things you can do out there with magistrates and policemen. Again, the Attorney General of the United States says he's just not arresting anybody anymore if they meet a certain criterion. The next thing you can do, and these are all cases I've had, I'll gladly share the transcript with anybody. I had a lady who talks about the best day and the worst day of her life. It was her son's 3rd birthday, I think. We have it on video, by the way, if you ever want. Or you could go to our YouTube site and you could actually hear her tell her story herself with a blurry face, thanks to the technological abilities of Video Standard and Dante Ludovisi. But we have YouTube videos, and she talks about her going to her son's birthday. She went to the drugstore. She was a person who was writing prescriptions in she was a nurse, several pharmacies. And to make sure they didn't get on top and detect her, she was doing it in multiple counties. Prior record people are starting to get your ear perked up. And over a course of 2 or 3 years, I think she embezzled over $150,000 in marital money. And she was buying, there are cases where nurses go in and they'll take that paper cup where there's medication and they quickly throw it in their smock and set it down like this old person took their medication, but they really didn't take it. Okay. But anyway, nurses have that stuff thrown at them constantly. But so she's going to the drugstore, and the pharmacist in this day said, it'll be a little while. So she's going up and down the aisles buying balloons for her son's birthday. It's his 3rd birthday, and she's going to have a party for him. Pretty soon she notices a policeman go to the door, and she notices another policeman at another door, and she could hear them things talking to each other. And the pharmacy had alerted them that she's back. And she describes them taking her to the car and the little boy hanging on her leg screaming, "Mommy, Mommy, no." And she went to jail. They took her directly to jail. Now, she immediately called us, not that we're anyway, I don't know how she even knew about us. It was from a county. We don't do that much work in. She may have called the doctor and somebody said something, but she immediately got in the, back then I think it was the tablet. She maybe not even had the injectable yet. I know she eventually went to the injectable. And the state attorney general in Pennsylvania, eventually, we kept on continuing this and showing her compliance with the treatment. It was part of her bond. About a year later, they only filed charges in one county. It was Beaver County, and they gave her what's called probation without verdict. She had multiple counts. She had hundreds of prescriptions. Hundreds of forged prescriptions. There's multiple counts to multiple events. She'd have done at least 6 years in the state penitentiary. By the time she got done pleading in all 3 of the counties she was doing for several years. She did probation without verdict, and she says it was the worst day, best day of her life.
She have her license?
She actually got her license back.
Wow,
Yeah.
that's kind of scary.
Well, she got her license back only by compliance, though. She had to do the behavioral modification contract, submit it to them. She went 2 or 3 years without working. But she was put on this probation thing on her license requirement. She is totally, fully recovered. She actually wanted to keep taking the injectable blockade, and the doctor actually wouldn't let her anymore. She wasn't addicted to it, but she just felt so good with it, you know. So that's a case application there. And if you want, let me see here. I'm going to give the section citations to that. You have a document in front of you, other than that research. The next document says Drug Act. You may not be aware, but there's some important drug legislation in the Drug Act that would help you. The most important one is Section 780-117, probation without verdict. And what that means is that if the elements are there. If you prove that you have a drug problem, and you prove that you're in treatment, and you have medical testimony, you can get probation, and eventually they will dismiss the charges and there will be no verdict. That's what she got. That's the section in the Drug Act. And I guess it's page 193 it might be, I think. Probation without verdict, including all of the elements necessary. Now again, you're going to need an addiction physician for some testimony or some certificates, but give us a call. We can definitely share with you where you can find those guys. Then there's another part of the Drug Act, it's 78118, disposition in lieu of trial or criminal punishment. That's for somebody who's a little more fault-ridden, more culpable, but it's again the similar theory or the similar theme, and if we have time, I'll go back and touch on some of the elements of that. But for right now, you need to know it's in your Drug Act there. We have a case in Virginia right now. We have a girl that's in prison right now in Virginia. I don't know if you guys know this, but you certainly know that Virginia was the birthplace of our democracy, right? Any of you who study constitutional history know that James Madison was instrumental in the Constitution. And he and his cohorts, especially with the Bill of Rights, right? So the Constitution wasn't good enough. They go even more further for the individual rights. In Virginia, when you try the case to a jury, when the case is over, if you lose, you immediately come back the next day and the jury decides what you're going to do for as punishment. The jury will sentence you. And the jury is not allowed to go below the guidelines, but they're allowed to go above the guidelines. Imagine that for a somber thing for deciding whether you take your case to trial. In Virginia, you file a request, a petition for permission to appeal if you have an appealable issue. And if they say no, then you don't get an appeal. It got so crazy that they rejected our petition because we didn't send it in PDF, and the email that we sent it to, although we certainly said we served the other attorney, it didn't say in the CC line on the email that we sent it to him by email, and they were going to dismiss it all. I mean, it's really, really rough down there. This is a case where a lady was drinking. She was on, we got her out. She had 4 DUIs, and she had like 3 of them within 2 or 3 months, 2 of them within 2 weeks of each other. This last one, she ran into a judge's car and took off in Virginia, and he was one of the judges in this courthouse. And she had her kids in the car. She definitely had an alcohol problem, and we actually got her released and got her a wonderful plea bargain, and she was on Vivitrol, on the medication. Now, this has some really weird twists to it. Somewhere after about a week, after about a month, whenever somebody takes medication, one of the first things that they do is feel better. And when they feel better, they start thinking, I don't need any medication anymore. I'm pretty well cured. Your own life experiences, I'm sure you have many times where you have a prescription bottle that you didn't take the rest of the prescription because you think you're feeling better. She felt that way, and people do feel that way with the Vivitrol. She just quit taking it. It was a violation of her behavioral modification contract, and the auto reporting kicked in, and we sent all kind of notices to adult probation. Adult probation sent back notice to us and told her that as far as they're concerned, it's not a term of the probation, and they're not going to make her do it. Mind your own business, basically. It was amazing. And she quit taking it. And then she started to lose confidence in us, too, that you told me I had to do this, and I didn't even have to do it, So life goes on, and we move on, and she moves on, and then I get a frantic phone call some 4 months later from her mother saying that adult probation, by the way, in Virginia, when you sign a probationary order, you have to sign this amazing waiver of all your rights of privacy, that they're allowed to go in your house to search you anytime they want, with or without probable cause. It's bizarre. They kind of like kicked down the door, basically, of her house and found 4 beer cans on her counter. And they ran over and tested her and found out now she was at home. She wasn't drinking and driving or anything. She was home. She panicked. She tried to do the right thing and told them she was drinking. So they hauled her back in front of the same sentencing judge. And the sentencing judge sentenced her to 3 years in prison for violating the probation. By the way, in the Drug Act, let me see here, there's a section. I'm trying to find it in the exact section. But for those of you who find somebody who's being revoked because they had dirty urine or something like that, there's a strong prohibition, and many times just plain out illegal, to punish them for that. It's actually in 71 PS 1690.106. And I may not be giving you the exact site. But in there, in the sentencing issues, is that it is so, again, this is before we are now, it is so likely that a person will relapse that you're not really allowed to punish a person for a relapse. Anyway, that's out there. And back to our Virginia case, it's another one of those cases where who you are, comes to bear. Nobody wants to be standing there and being being a problem for the judge and whatnot. But Bruce was with me. He certainly can, he can remember this. This judge was all over me. I mean, there was a point in time I remember very well where the prosecutor said, "Objection, Your Honor, blah, blah, blah." And I said, "Well, Your Honor, that's not yada, 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 making an offer of proof." He said, "Mr. Papa," he said, "I said sustained." And I still am sure that he did not say sustained. And certainly, even if he did, I have a right to make an offer of proof. And I said, "I'm sorry, Your Honor." I'm trying to, get along. I said, "I'm sorry, Your Honor, I really didn't hear you. Next time I'll say it louder." I mean, that's the kind of thing was going on in that afternoon in court. And when it was all over, it was like, really, and then he clobbered her and sentenced her. The interesting part of that is how it ended up. When it was all over, I was packing up my briefcase, and he said, "Mr. Papa," he said, "it was nice having you in our courtroom." I looked around like, who came in? And I said, "Excuse me, Your Honor, may I approach the bench?" And I said, "I'm kind of puzzled." I said, "Because, I mean, you seemed like you were having a problem with me the whole day." "No," he said, "I learned a lot about drugs and drug courts and stuff." He said, "It was nice having you here." He said, "You are annoying, though." And I said, "My wife just told me that 2 hours before I left to come down here." And he said, "I don't doubt that either." Anyway, so we kind of like left off, and it was kind of friendly. But right now, that's on appeal. And we actually, September 17th, have a hearing in Virginia on this. This is all new stuff, by the way, all new law. So going back to how it fits in procedurally, again, we have the preliminary arraignment, we have the preliminary hearing, and now we have the call to trial process. Now, I believe, remember now, we want to give the prosecutor, John Davidson Rockefeller, right? We want to give the prosecutor something that he wants. So we have the treatment argument, but again, remember the Sixth Amendment, right? If I have a legitimate pretrial issue, it would behoove me to throw that in the pan, because at worst, even if it's a pretrial procedure or an issue that's really testing the limits of what we defined as frivolous, we certainly have the prosecutor wanting to not go through all that. So if you have don't forget you're a trial lawyer too. So let's not get so caught up in all this fancy stuff here that we forget that too. And remember too, and I think it's an underused thing. A bill of particulars, how many people in here have ever filed a bill of particulars in a criminal case? I mean, I love it. When I was a prosecutor, I can't tell you how many times a case was going bad and I started doing another theory halfway through a trial. And I could do whatever I want because nobody asked for discovery, nobody asked for a bill of particulars or nothing. But the bill of particulars, now we do know there's some bill of particular hang-ups though. Let's talk about that now that we opened up that can of soup. What do we know about a bill of particulars, sir? We have to do it within what, 7 days, right? That's a deadline. Now, let's suppose I'm the Commonwealth and I don't respond at all. And they do that a lot, by the way, just ignore it. We have to demand within 10 days that they answer that, or we're waiving that. So don't get caught in that trap. And the bill of particulars, you can actually particularize, and narrow it a little bit. However, the government's attorney will claim that that's really a discovery issue. That's not a bill of particulars. And there's a line of cases out there on that. And of course, discovery. We always want to, I don't care if the DA says you can come and see my file anytime, you always want to file a discovery request. Days, help me over there, 10? Right? Is it 10? Again, the arraignment date is where it all starts, right? From the date of arraignment, we have 7 days to file the bill of particulars, and I believe we have 10 days to file a formal discovery request. And most often, they want an informal discovery request before you even file a formal discovery request. So what I do now, my secretary just automatically sends that stuff all at the same time instead of counting 10 days and all that. So be careful on the deadlines. But why are we doing it with a formal discovery? Are you puzzled on
I'm
that?
puzzled about the bill of particulars. How's that going to benefit your client?
On or about,
What do you need to do?
yeah, on or about the 7th day of January, the person is alleged to have written a prescription and handed it to Giant Eagle. I want a bill of particulars as to what time it was, who it was handed to, particulars, the details. Sometimes they don't know that. And that's good to know that they don't know that. They might not have a witness.
But wouldn't that be in the affidavit?
No. Don't rely on that affidavit of probable cause, right? You know what the heck you're going to find in there. But anyway, I would always file a bill of particulars. Certainly file a discovery request. And even if I have discovery and I'm not going to get any more, I want them to sign a piece of paper saying there's nothing else in this file. How many times you could go to court and it'd be 17 months later, you're going to trial, and all once you find something in there that's about ready to admit into the record that nobody was knew. So the discovery not only gets discovery, but more importantly, it confirms that this is all there is in this file. A little follow-up letter. That was so nice meeting with you. This DA's office is so courteous, and you were so helpful, and we are so glad, and this is to confirm that that's all that there is in this file, and that you'll give me anything new. Bam, that slams the door shut. I mean, I guess they could get a continuance if they found something else, but normally the judge will be all over them, say, come on, you're trying the case, and this is what your evidence is. So, again, those are the procedures. Now, here's where we get to the problem. Go past that issue, and we're now going to talk about what I call the ultimate, if I were selling cars, I would not practice law if I were allowed to do this because I'd rather sell cars. Okay, I want to sell a car. Well, they're about $25,000, $30,000 now, right? I want to sell a brand new car. What if I were allowed to order everyone who is going to purchase a car to show up at 9 a.m. on Tuesday, August 20th, 2013. Would that be an advantage? Duh, right? And I will go to them and say, I now know who wants to buy a car, and I know they need to buy a car or leave. And I will tell them, I need $40,000. Take it or leave it. And if you leave it, that's okay, but the price will be $50 tomorrow. Isn't that what they're doing with call to trial? I'm ordered to show up here, okay, and I've got some shivering defendant who has no clue what the heck is going on. and I'm told that you're going to plead to state penitentiary, take it or leave it. Well, gee, what about the fact that he didn't call his mother like it said in the affidavit? Or probably, listen, I'm just the guy who's assigned to call to trial today. You need to take that up with somebody else. All I'm saying is this is the plea offer. And we know if we go to trial, it'll be twice as bad. That's bad, isn't it? In Allegheny County, it's inhumane how they do it. I had a case once in Allegheny County where I kept on going down to the DA's office, and I would show up and knock on the door. I would call with an appointment. I wanted to talk to the DA about the case. DA doesn't talk to you about that case. DA will only talk to you on the day of trial. I mean, so what they're doing is they're narrowing all of your options so that you've got to do this, okay? So,
This is the current administration,
what's that?
or this is recently?
That's not recently, no. But I'm pretty sure Zappello was the DA at the time. That's what they do. I mean, isn't that what they do in Allegheny County? They're not going to talk to you about the case until the day you pick a jury or pick a plea. I may talk a little bit, maybe a little wee bit. I might be able to do something for you. But, man, and you're running out there between the defendant and he's looking at you like, you moron. You waited until the last minute to get this thing worked out. Now you're making me decide this in 2 minutes' time. This is absurd. And it looks like you did it. And I'm telling you, there's nothing you could do about it. They do it at every courthouse in the country. And when I was a prosecutor, they didn't have call to trials. Call to trials is what I call DA babysitting, so they don't lose a 600 case. They put them all on the list and make sure that everybody has to show up. And how about this for being crazy? I do 32, I've been in 32 counties, and many times they have them the same day and time. And you got them all over the place. So it's really a leverage position. It's very, very strong leverage. So what about Pennsylvania Rule of Criminal Procedure 570? Okay? Pennsylvania Rule of Procedure 570 says, pretrial conference, at any time after the filing of an information, upon motion, or upon its own motion, the court may order the attorney for the Commonwealth and the defense attorney or the pro se defendant to appear before it for a conference in open court unless agreed by the defendant to be in chambers to consider, I'm going to skip all of them, number 6, such other matters as may aid in the disposition of the proceeding. Isn't that a great way to make your treatment argument? I tell you what a bad place to make your treatment argument is when you've got 50 other people standing behind you and it's plea day and you have some judge in Meadville say, Mr. Papa, what do I need to know any of this for? And you're embarrassed and it makes you, humiliates you in front of your client like you got your degree from the back of Detective magazine. All those things are going against you, you know. That's kind of, you know, an option for you if you can pull this off to now bring this to the forefront. And many times if you get the right judge, they'll actually fence with the DA a little bit about cutting this off and cutting that off, and you can end up getting yourself a deal. Now, caution, there may be times where they'll just send it back to you saying denied. If they do, I think you could probably file some kind of an appeal. I think that's an appealable issue that you were denied that. Not then, of course, you'd have to wait till the result, right? That would be.
If the judge rejects the plea bargain?
No, I'm talking plea bargain. I'm talking about you asking for a conference because you don't have a plea you want yet. This is Rule 570. I have had them come back from some judges with just the word denied on it. And I think if they were tested on that, they would claim that we already have a procedure in our office. That's what call to trial is for, or something like that. But again, that's hard. They're going to be hard to justify that. I think you have a decent chance for an appeal after it's all over on that issue.
I think it's discretionary.
Well, it doesn't say so in this rule here. It says everybody's allowed. And I can tell you what, if we're talking about what happens to the defendant afterward, and you've got all this evidence about treatment and how he's in the program and all that stuff like that, I think you've got a pretty strong argument that you should have been heard on that. It is a tool. It's an attempt to pull your case out from under. You know, for example, you got some big drug busts and there's 50 defendants. First thing you want to do is file as many continues as you can. Get the heck away from the crowd. Let them all get clobbered and have your case come up later and somebody will cut a deal that now it's no longer a big deal, right? When you got multiple defendants and whatnot and your person is in the pile, you want to separate them from the pile. You know. Anyway, that's Rule 570. Okay, now, we now have taken the person to pre-trial, call to trial. Always, you're leading with this treatment thing, and I am telling you, each one of those intervals are an interval of work for the prosecution, which is always a bargaining thing. And it's also another opportunity for the defendant to stay involved and successfully in treatment. That is so important. And at the end of the day, even if you were forced to go to trial and lost, I haven't got that far yet. I've never had to. At the end of the day, if you went there, you would eventually be making a sentencing argument. I believe that is the lost art. It is something people don't do. Sentencing is a proceeding that gives you an opportunity to actually impact what's going to happen to this defendant. And number one, if you've done the treatment thing, as I told you, you have evidence that nobody can rebut. You have evidence of this person's likelihood to repeat, which is the most fundamental and important function of sentencing, except for mandatories, you know. I don't know, I'll talk to you about mandatories in a minute. But sentencing is a lost art. And what's cool about sentencing is the prosecutors rarely do a very good job at it either. I was a prosecutor. I can tell you right now, it was my day to do sentencing. They'd give me a pack of files. I'd go up and set those files down. I had no clue who the heck these people were. All I knew what the plea bargain was or what he was convicted of. And I'd stand there and shift my weight to right to left, back and forth. And what do you have to say about that, Mr. Pape? I'm opposed. Why? I don't know. I'm just opposed. I'm supposed to be opposed. You know. I mean, that's what prosecutors do. And so you can win that argument because you won't have an argument against you. So shame on you if you neglect that argument. And by the way, in the afternoon, we will actually show you a video of one of our presenters who could not be here today on sentencing and give you some law, by the way. You have no idea how many of you could be ineffective or malpractice, probably ethical breaches. You got to spend lots of time with the defendant on what the plea bargain was, what the possible consequences are and all that. And that little document they read to them in court called the colloquy, that's just a show. We know that. That's not really substantive. And shame on you if you're not still, what's a good lawyer do? A good lawyer spends time with their person before they're wedged in the hallway like this, okay? And how does that work? In my office, I gladly take some of the money I was paid and I will hire a guy who's a former public defender or something to give them a second opinion on the sentencing. And that second opinion will be first and foremost a complete range of how bad this could be, high and low, concurrent, consecutive, mandatory. And by the way, the DUI while driving suspended, if they sentence you, what? Anybody? Concurrent, consecutive? Somebody help me here. I'm teaching the rest of the group. I know you guys know it inside and out. What's bad, concurrent or consecutive? Right. So if they sentence somebody consecutively on top of each other, right, instead of concurrently at the same time, many times prosecutors will yield on that argument. They'll, okay, you're going to plead to, but I'll do it concurrently. Many times people forget that. So I always get a second opinion from somebody, and I'll give them $100 or $150 to give me a write-up. And by the way, what would you do? Well, if I was you, I think I'd take the plea or whatever. But I like having a second opinion for the defendant so that, again, that's what I think a good lawyer does. So now we're to the sentencing phase of the argument. And again, I think with all of this unrebutted medical expert testimony, I think you probably have a decent chance to file an appeal on the sentencing too. Because we know there's limited basis for sentencing. And somebody brought this up, and I definitely want to clear this up. Pleading. From the time you enter a plea until you actually are sentenced, true or false, you do not have an absolute right to withdraw your plea. Do not, right? So you must make sure you tell your client that. You don't. Now, practically speaking, you can withdraw a plea almost anywhere, but you don't have a right to do it. And each day after you enter a plea, it starts to go further against you. Sentencing. Again, you do not have a right to withdraw the plea the day before sentencing. It's less likely than the day you entered the plea. But after sentencing, I don't know of any judges that will let you withdraw your plea. So you need to prepare them for that too. And I'm telling you what, even when you did your job, I can't tell you how many times somebody's going to say, you never told me that. I don't know if they're not listening or whatnot, but it's very important on that sentencing aspect.
Evidence of rebuttal, for example, let's say the person's been in drug court and they have relapsed, reoffended, whatever. What do you do in that case?
I would definitely, again, that's all the more reason why you want to make sure you have treatment that's not a sham, treatment that's realistically effective, because the stakes are very high. They make many times in these drug courts, they make you trade everything. You know, drug courts are not traditionally like ARD courts where you're not, if you wash out, you get a chance to go back on the trial list. You usually have admitted you're guilty just to get in the drug court. So those kind of things need to be sat down with that person and say, listen, you've just traded it all here, you know. Anyway, I'm going to have to skip past that, and I'll gladly answer questions later, looking at the time. And I'll be able to pick some of that up in a little bit. One of the other things I like to do is look at history as an important thing. And all of us, at one time or another, have at least casually been interested in the Titanic, right? It was the 100th anniversary of the Titanic, was it not, this past April 12th? The Titanic, by the way, all the relics and artifacts are on display in Cleveland, Mr. Cleveland back there. It's one of the nicest displays I've ever seen, probably. And we're talking about they actually have the bell that was rung when they saw the iceberg and whatnot. They got it all there. They got cabins and silverware and everything. It's a neat place to take your kids or grandkids or whatever up to Cleveland. It's there till January. But the Titanic was the largest moving man-made object on the face of the earth at the time. Everybody thought it was completely unsinkable, okay? And it was huge. And we know the end of the story, how it sank in less than 2 hours and all the compartments and whatnot. There's a couple lessons that the Titanic teaches me, and I try to teach it to young lawyers. The first one is to not duck a hit. Remember we talked about lying and say, I filed your lawsuit, but I'll get it back to you later. The Titanic, most experts agree, if it hit that iceberg head on, there'd have been 100 million ice cubes in the North Atlantic, but it probably wouldn't have sunk. It was that pulling it, and it maneuvered very slowly. My daughter, Annie, wrote a great paper on it. She's a Titanic freak. And it ripped enough compartments that they floated over the bulkheads and took the ship down and split in half, and the rest is history. It's what happened on the deck of another ship that's more enlightening for where we're at. Most people aren't aware. It's a really neat book if you want to read it. It's called The Other Side of Night. It's a real small book, but it's neat. At the same time, the Titanic was issuing its CDQ. SOS was brand new at the time, and it was called CDQ, All Stations Disaster. How about that? You know, these kids going out texting and whatnot. John Davidson Rockefeller built that huge financial empire on dots and dashes. You know, that's how people communicate back. Anyway, CDQ, CDQ, CDQ. At midnight, that distress call went out, and the captain on the Californian, Lord, and the captain on the Carpathia heard it at the same time. It was brought to their attention at midnight. The Californian is 5 miles away. The Carpathia is 58 nautical miles away. Now, the Other Side of Midnight talks about how the officers in their white uniform took turns and they're shoveling coal in the Carpathia. And their boilers had never been pushed that hot, that long. And remember now, the largest ship known in existence just hit an iceberg and was going down. They're going through the same dangerous waters of the North Atlantic without navigation. All they know is this ship needs help, and I'm going there. I don't have any answers, but we're going there. And there's discussions about how the rivets looked like they were stretching on the boilers. And they're shoveling faster and faster and faster. And they got there at 4 a.m. Everyone's gone. 700 some people were left in lifeboats. The Californian never moved, 5 nautical miles away. Watch the flares go up. Later they'll testify in Senate hearings they thought they were having a party or something. Which, by the way, nautical law at that time said that those are distress signals and you can't ignore them. My message is this, that if we take a look at history, I want to be on Captain Rostron's ship. Maybe I don't have all the answers, but I know that one is not letting that kid die after he was released from jail. 780 people, there's a lot, 1,500 drowned or so, but 780 people did survive. 780, we didn't save the world, but we saved the world for 780 people. So what a good lawyer does is a good lawyer does whatever he can for one person at a time, if that's what you're called to do. And I'm hoping in some way that when you get to the end of this thing, especially when you hear Mr. Lindsay's program, which is really, really good. He's a lawyer's lawyer. I can tell you this, that you'll connect the dots, and at the very least, you're going to be proud of who you are and what you do. Now, the last part of what we do, and it's summarized in this book here, is that we have decided to connect the schools to this by adding the professional educators, emphasis. We now have these drug summits in which we invite all the doctors and all the lawyers and all the politicians to come to the court, to come to the school. And lawyers will get CLEs, doctors will get CMEs, teachers will get Act 40 hours. More importantly than that, they sit in the same room with each other and talk to each other. When you start working together, that's a very powerful thing. Lyndon Johnson, and I've never been a Lyndon Johnson fan. It was probably hard to be Lyndon Johnson's fan. How could he ever follow John Kennedy, you know? Probably a lot of that was probably unfortunate. But I got a lot of other problems with Lyndon Johnson. But one of the problems I don't have with Lyndon Johnson is what was on his wall, Isaiah 1.18, "Come, let us reason together." I don't know if we have all the answers, but I think we have a heck of a lot more now. Shame on us if we sit and not move the boat because we don't know all of the answers. But I believe that the secret here is getting everybody in these schoolhouses, doctors and lawyers, to come together. And isn't that what community leadership is all about? I've already told you about how much power the legal profession has, and Al's going to tell you how much more that you have as an individual attorney. So if you take that most motivated patients, and the biggest problem America has right now, and you actually use that forum to make all these treatment independent professionals work together in an extended care plan that really is viable, not something that's a phony sham. And then we get with the educators who are going to, they're professional educators. How many of you wished you had a professional educator instead of the law professor you had sometimes? These are professional educators, and if we get them to come together, putting everybody in that local schoolhouse and teaching them, then we really have done something. So please, bless you, take some time to review this last section here of what we're doing. It's all nonprofit. We need more teachers. We need people who want to be involved. And we're having a 2-day event at Kennedy Catholic High School. And I guarantee you that when you start doing this and reason together, we don't have all the answers, but we have more answers than we've ever had before. So I thank you for being attentive. Now I'm going to help out who's going to be doing the middle section here with some techie issues, but for the most part, I'm done. And what's going to happen now is we have somebody else coming on who's going to teach us more about that drug act, and then we're going to have a professional educator who's going to talk about, introducing Mr. Lindsay, and Mr. Lindsay likewise will probably go without the breaks too, so you'll be able to get out earlier, but that's his thing. I don't know how he wants to do that. Welcome again. I'm Attorney Angelo Pepa. I'm the instructor for today, and I have a privilege of having other gifted, seasoned veteran attorney instructors with me, and we like to give people something more than just reading to you off of the document or whatever. But we have accomplished both, I think, by giving you voluminous information that you're encouraged to look through, and you're also encouraged to ask us or leave me your email address, and we can put you on a list that every time something new comes out in these topics, we can just send it to you on like a research deal. So that said, we want to proceed. And our next area that we're going to be dealing with is, again, picking up with this theme that overrides all the topics we present on being a good lawyer, not being a perfect lawyer, but being a good lawyer. What does a good lawyer do versus something that's you're not so proud of or have? And many times you have to sacrifice according to Rule 1.2 in our ethical rules, by the way. It says that you're supposed to put personal sacrifices aside for the diligence of your client and whatnot. So being a good lawyer means to work. And the area that we're going to go into next is an area that I'm really excited to add to our program. It's all about sentencing. And I want to make sure I give you some case citations because it is not in the material that I gave you, but I'll gladly email it to you. We call it sentence advocacy. And one of our instructors that normally comes with us was at our drug summit last year in Kennedy Catholic High School, and hopefully we'll be back again in November of this year, which again is 2013, November 15, 16, Friday, Saturday at Kennedy Catholic High School. And these are important cases for you to know. Missouri versus Fry, 2012. Lafler versus Cooper, 2012. Miller versus Alabama. Powell versus Alabama, 1932. Gideon versus Wainwright, 1963. Strickland versus Washington, 1984. And some of the sections that we would be discussing when we get to this segment would be county intermediate punishment, 42 PS 2154.1, state intermediate punishment, 54.2, work release, county or state probation supervision, electronic monitoring, halfway houses, house arrest, drug and alcohol treatment, inpatient mental health treatment, problem-solving courts, pharmacotherapy, Miller versus Brass Rail Tavern, 1995, and Fry versus United States, 1923. And the gentleman that will be teaching this segment, like I said, will be teaching by video, and the section we'll be teaching is the section dealing with those issues, and his name is Matthew T. Mangino. He's a former District Attorney of Lawrence County. He spent a six-year term on the Pennsylvania Board of Probation and Parole. He is currently of counseling with other services. He's written numerous articles. He has blogs and various ways to get in touch with him. You can Google his name, Matthew Mangino. It's kind of neat. He was a football player back when I coached football, and he was like the star of the other team. And I had the star of my team, and we were playing in a championship game. And if anybody, you know anything about football, there's a thing called the I formation. In the I formation, there's a fullback up front, and there's a tailback right behind him. And we decided, I was pumping up my guy all day, all week long. I said, this is how I went about it. I said, you know what, Chuck, I have a job. Well, never mind. And he said, excuse me, Coach, what'd you want? Never mind. I'm not going to put that kind of pressure on you. Never mind. And for the rest of the week, he's, what? What did you want? What did you want? Well, I just know that this kid is the best they have, and I thought it would be an honor I would bestow on you to deliver the first blow from our side of the line of scrimmage to let him know what kind of afternoon he's going to have. But that's not fair. That's putting pressure on him. From the rest of the week, he's begging me. And then, of course, we designated him the ISO block, the thing. And I probably got sued for that. I don't know. But the bottom line is he ends up turning out to be a very well-respected attorney and a member of our... And the other guy, by the way, is an attorney, too. So we want to go into the sentence advocacy. And I can tell you this, it's very important for you to understand how important that is and how easily you could be guilty of an ethical violation. And John, we talked about this, you weren't here this morning, about how Allegheny County style is to leverage you into the hallway and tell you have 15 seconds to plead or go to trial. And that in and of itself may be a very practical way of administering a clogged docket, but it sure gives us what we call heartburn and whatnot, knowing that we got people out there thinking that we're not prepared and whatnot, and it's very unfortunate to do it that way. We talked this morning, and I'm not going to repeat, about ways in which you can avoid that, including the 570 conference that you could file for in pretrial under the rules of criminal procedure. Anyway, moving along as quickly as I can because we're accelerating our schedule. I want to bring to your attention another historical vignette. How many people in here are fans of Franklin Delano Roosevelt, or at least think he was a superior statesman? And certainly he was. You have to read his biography sometime. It's an amazing story how his waist and chest, it was getting near his lungs, and it just quit working one day after he was swimming. And what a scary thing that was for him. If you read his biography, it's pretty shocking. But the thing that I'm always upset with is the lack of proper attention they gave to one of his most famous quotes. And that most famous quote is what? The only thing to fear is what? Fear itself. Well, guess what? I think they leave out the most important part of that, okay? And I have a quote from that speech. Roosevelt had a simple but intense religious faith, and the speech is suffused with biblical imagery. The money changers have been driven out of the temple, etc. This great nation will endure as it has endured, will revive, will prosper. So first of all, okay, let me assert my firm belief that the only thing we have to fear is fear itself. Now this is the rest of the thing, and these ways you have to talk to your client, I believe. Nameless, unreasoning, unjustified terror, which paralyzes needed efforts to convert retreat into advance. That is what the fear is. Everybody's afraid, everybody's worried, everybody's concerned. I tell clients all the time, listen, this is something you should be concerned about but not worried about. This is something you should be fearful of or respect, but not nameless terror that paralyzes you when we need you involved. And more than ever, in the substance abuse case, and we talked about that being the critical ally of a substance abuse war, the ally that's been missing all these years in that new pharmacology that can bring them on board, that is the kind of fear that we have to resist, and that is the kind of thing that lawyers do. Do we solve all the problems? No. Do we tell them what they want to hear and paint a rosy picture, only have them be disappointed and say, wow, what happened? 5 minutes, I thought I was going home, and now I'm going to jail. No, we don't do any of that. A good lawyer prepares them to deal with it and respect it and be concerned, not paint it away, but at the same time not let it paralyze and terrorize them. Now, with regard to sentence advocacy, that works very close with plea advocacy and how to properly prepare a defendant. And I would like to now, at this point in time, we'll probably go off record, Mr. Ludovisi, and we will now go to our segment on the TV, okay? Great.